to draw this.
Okay. Mister, your name, please?
Yes, Burman.
Mr. S. Borman, learned counsel for the accused, submits that he has the instruction to withdraw this petition. Fair allowed. This will be a sense disposal on withdrawal.
Obliged, Lord.
The number 51 for withdrawal.
Lordship, petitioner may be allowed to withdraw the petition, Lordship. They will approach the learned trial court and with a liberty to file afresh.
Liberty will be required.
Yeah.
The Mr. Majumdar, learned counsel for the accused, submits that he has the instruction to withdraw this petition. And he also submits that the petitioner may be granted liberty to approach this court again by filing a appropriate petition. Fair allowed. This obeys the disposal on withdrawal. However, liberty will remain with the petitioner to approach this court again by filing appropriate petition.
Online.
Motion BA item 2.
My lord, I am in jail for 37 days. 38 days. My lord, notice baby. She will call for my dear.
What are the allegation?
My lord, allegation, my lord, your lordship kindly see, but only allegation that I proposed to marry that girl, my lord, and in the pretext of marriage, my lord, there is a physical relation is there, my lord, and ultimately their marriage was not solemnized. That's why that FIR has been lost. My lord. Very well drafted FIR is a long, very long FIR, my lord. In fact, my lord, it was on
What is
29th
wrong
7,
with
2020,
well-drafted FIR?
my lord.
What
Well
is wrong with
drafted, very
well-drafted FIR?
There is a reason, my lord. Your lordship kindly see each and every, my lord, they have stated what they have, that from background of the, my lord, the content of the FIR is that, my lord, all along, my lord, we have a relation with that girl, my lord. And my lord, on the pretext of marriage, my lord, we are moving around from Gauhati to Gauhati and various places. And your lordship kindly see there is a one allegation that there is a abortion take place. But that is took place in long 1 year ago, my lord. After 1 year, my lord, they have filed this FIR, my lord. Why I am calling for CD, my lord? Because in last occasion, your lordship dismiss it, my lord. That is, my lord, I have annexed that order. So,
Earlier dismissed.
yes, my lord. Not that regular bail dismissed. So, my lord. I have annexed that order, my lord.
After perusing the case diary or without perusing?
Page number 26, my lord. Observation is page 28.
After perusing.
What is the new ground then?
New gown, my lord, I have taken 2 new gown, my lord. One new gown is that, my lord, that 1 year, my lord. After 1 year, my lord, that alleged, my lord, abortion, my lord, that FIR was lost, that was not been placed before this honorable court. Now, I am the person, my lord, who, my lord, apply for, my lord, registration of our inner certificate, my lord. But that, my lord, is pending. That was also not placed before this honorable court.
Okay, let the city come.
My lord.
When Bortaka?
Already 38 in jail, my lord.
26. 26.
My
Item 3.
May I please, Lordship. Lordship, second time bail application, Lordship, rejection order is page 94. Lordship. It is 41 days.
So what is the new ground?
My lord, new ground, my lord, earlier, same arms earlier seized by the Nobukuri police station. My lord, kindly see page 78. My lord. This is my Zimbabwe petition, my lord. After I approach the Zimbabwe petition, the arms is allowed to me, my lord. After full verification, my lord. My lord, kindly see page 84, my lord, order. Zimbabwe petition allowed, my lord.
No, Zimbabwe petition is allowed. That is a different matter.
My lord, same arms are not earlier seized by the police, my lord. I approached the Zimbabwe petition, my lord. The Zimbabwe petition was already allowed after verification, my lord.
No. This order was passed on 5/8/2026. After this order, what change of circumstances have taken place in your favor
My lord.
to approach this court again by filing
Not call for
bail
the city,
petition?
my lord. At the station calling to
Hmm?
CD, my lord.
Okay, what account? CD?
Updated.
Updated case ID, fixing the matter on
Obliged.
27. Okay.
Obliged.
Item four.
Because if though we have filed this petition under 482, my lord,
Hmm.
our apprehension of arrest, my lord, is not from police, but from the trial court, my lord. There is a practice going on, my lord, wrong practice going on in some district judiciary that, my lord, whenever accused appear before the court during summoning stage, my lord, when he appear, my lord, accused appear, immediately he is taken into custody, my lord. And then trial court insists the accused to
No, how that practice is wrong?
my lord, this is contrary to the law, my lord. There is
How-
specific provision, my lord.
If the magistrate has no right to, no power to grant bail,
Yes, my lord.
then
Absconding during summoning stage, my lord, it cannot be, my lord. Once the summoning stage is over,
no,
warrant
whether
stage,
the magistrate is not supposed to consider the nature and gravity of the offense?
my lord, that is once the accused is absconder, my lord, during the investigation stage,
Mm.
and after that, my lord, when charge sheet is filed, court used to take cognizance.
Mm.
Thereafter, issue summon.
Mm.
Summoning stage, my lord, these things are not to be considered. Once the summoning stage is over, my lord, that
What is to
bailable,
be considered?
my lord, for that, my lord, I will, my lord, lordship will come to section 91 of BNSS.
Mm. What is there?
Just for a moment, dear. So, my lord,
What is there?
in 91, my lord, lordship will find earlier it was 88 of CRPC, my lord.
Mm.
In 91, my lord, power to take bond or bail bond for appearance.
You see, there is a division, no, full bench decision of this court and also of Supreme Court that magistrate has no power to grant bail in session travel cases, and here it is a commercial quantity of NDPS.
Exactly, my lord.
How can the magistrate grant bail?
No, he is not magistrate, my lord.
How the
It's
practice
special judge, my lord.
Yes.
His trial is going on, special judge NDPS, my lord. Case is pending before special judge NDPS, my lord. Even in September until also, my lord, in para 100.5, my lord, it was mentioned that there need not be any insistence of a bail application while considering the application under section 88, 170, 204 and 209 of CRPC. So, my lord, there is ruling and also, my lord, section 88 of CRPC or 91 of BNSS, my lord, is clearly says, my lord, during summoning stage, my lord, a trial judge.
No, you see, section 37 is there.
My lord, rigors of
In
37 is
respect of a
definitely there, my
commercial
lord.
quantity, the court has to, you have to satisfy the same.
But, my lord,
Only then the trial court can grant you bail.
my lord, that stage will come after issuing, my lord, warrant stage, my lord, after warrant, during warrant stage, my lord, not before warrant stage. Summoning stage,
Now,
my
at
lord, no
what
one
stage
can be
the
taken
case
into
is
custody.
pending?
My
This
lord,
case is pending at what stage?
appearance stage, my lord. I mean, my lord, that someone has been issued, my lord.
The scan copy of the record we call for from the Court of Learned, special
My lord,
NDPS,
my lord, may I please, my lord?
where it is pending,
My lord, special judge Sri Bhumi.
Sri Bhumi,
May-
arising out of Bazar Sara PS case number 171 of 2022, registered under section 20B,
Ma-
Roman 2, capital C, stroke 25, stroke 29 of the NDPS Act.
May I pray one thing, my lord? Just one thing, my lord.
Sorry.
Our prayer is very
Let the
limited, my
record
lord.
come, we will consider your prayer.
Our prayer is very
Don't-
limited.
don't-
We want to appear before the trial court, my lord.
Sorry,
Need that protection only, my lord. We will appear,
no protection. Without going to the record, no protection.
my lord.
Call for it.
Item 5.
My lord, in this item, my lord, for item number 4, my lord, the date may be short date may be given, my lord. 27 is 200.
Okay, one.
May I please, your lordship? FIR page 9, lordship.
What are the offenses?
Offenses are under section 189, subsection 2, 140, subsection 326, 109, 118, 117 of BNS, lordship. CD may be called for, lordship.
What is the maximum period of punishment prescribed for the offenses?
109 is there, lordship. 90 days. 90
Life.
days, 90 days. Anticipatory bail application, lordship.
The person concerned is undergoing treatment.
Lordship.
The medical report, whatever.
Yes.
CD and medical report of the victim fixing the matter on when?
25th.
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 Oblige.
6.
None appears for the petitioner on call. List the matter after a week. In the event of subsequent non-representation, appropriate orders to follow.
Item 8.
May it please your lordship. Here I am appearing as a legal aid counsel. This revision is against the judgment and order dated 10/2/26, whereby the Honorable Session Judge had upheld the order of the learned CGM, sentencing him to undergo RI for 3 years and fine under section 326 and under 3 months under section 448, lordship. So
Heard Ms. B. Sharma, learned counsel for the petitioner, Mr. Borthakur, learned additional review for the state respondent. In this petition under section 438, read with section 442 of the BNSS 2023, the petitioner, namely Ratul Soikia, has challenged the judgment and order dated 10/2/2026 passed by the learned session Judge Golaghat in criminal appeal number 6 of 2021. It is to be noted here that by impugned judgment and order dated so and so, the learned session Judge Golaghat put in bracket hereinafter the trial court, learned trial court, has dismissed the appeal and thereby upheld the judgment and order dated 6/1/2021 passed by the learned Chief Judicial Magistrate Golaghat in GR case number 1495 of 2017. It is also to be noted here that by impugned judgment and order dated 6/1/2021, the learned Chief Judicial Magistrate has convicted the petitioner under section 326 IPC, 326 stroke 448 IPC, and sentenced him to suffer rigorous imprisonment for 3 years and also to pay a fine of ₹5,000 with a default stipulation under section 326, and also sentenced to suffer rigorous imprisonment for 3 months and to pay a fine of ₹5,000 with default stipulation under section 448 IPC. Peruse the petition and the documents placed on record, and also peruse the judgment and order dated 10/2/2026 passed by the learned session Judge Golaghat in criminal appeal number 6 of 2021, and also the judgment and order dated 6/1/2021 passed by the learned Chief Judicial Magistrate Golaghat in GR case number 1495 of 2017. Issue notice to the respondent, returnable in 4 weeks. However, no formal notice is required to be issued since Mr. Bortakur entered appearance and received notice. However, extra requisite copy of the petition may furnished to him during the course of the day. Justice shall call for the record from the learned courts below. List the matter after for it.
Lordship, there is an IA. He had already served 5 months, Lordship, out of his total 3 years period.
Let notice go ahead.
Lordship, no, there is no private party, Lordship. At present, he is
Then let
outside,
the record
Lordship.
come, we will see.
So,
For next
Lordship,
day.
3 years only, Lordship, 326. Lordship may kindly consider that, Lordship.
No. Whether the appellate court has not granted you bail.
Lordship, he is on after judgment, he is outside, Lordship, but that period is supposed to be over, Lordship. So he
He has been taken into custody
no, he is outside, but
presently.
presently. Sentence is 3 years and 5 months already. Yes. Statement accepted.
No, presently he is inside or outside?
Outside,
Outside.
outside.
So your prayer is to allow him to remain on previous bail,
Lordship.
or what is the prayer in the IA?
Lordship, I have prayed for releasing him on bail, Lordship, but as because at that time I have no instruction, but now I have instruction that he is outside.
No, if he is already on bail, where is the question of enlarging him on bail again?
Probably, Lordship, that period is over, and now they may that warrant or
Okay. Art, Miss
5 months I have stated.
Sharma,
At
B. Sharma, learned
Paragraph 10.
counsel for the applicant, Mr. Bortakur, learned additional PP for the state respondent. This application under section 430 of the BNSS 2023 is preferred by the applicant for allowing him to go on fresh bail. Ms. Sharma, learned counsel for the applicant, submits that the applicant has preferred one revision petition against the judgment and order dated 10/2/2026 passed by the learned session Judge Gauhati in criminal appeal number 6 of 2021. Whereby the applicant herein stood convicted under section 326 and 448 IPC and sentenced to suffer imprisonment for 3 years. And also to pay fine of rupees 5,000 with default stipulation under section 326 and 2 months under section 448 IPC. And that in the connected revision petition, the record has already been called for. And there is a requirement of allowing the applicant herein to go on fresh bail. Accordingly, taking note of the submission of Ms. Sharma, learned counsel for the petitioner, and also considering the submission of Mr. Bortakur, learned additional PP, and also considering the fact that the applicant has been convicted only for 3 months, 3 years, this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 20,000 with 1 surety of like amount to the satisfaction of the learned trial court, the applicant be enlarged on bail. In terms of above, this IA stands at disposal.
Much obliged.
Please, Your Lordship. So this revision has been filed against the judgment of the session court, my lord, passed in session appeal number in criminal appeal number 22/2024, my lord, where conviction of the petitioner under section 138 of the NI Act has been upheld, your lordship. My lord, my main grounds of appeal are at page 9, Roman 5, Roman 6, Roman 7, my lord. Mainly, my lord, as per requirement of section 138, clause B, my lord, which provides for serving of notice. That has not been complied with, my lord. Without compliance with that subclause, my lord, there can be no cause of action. And all around during the litigation, I have maintained my stand that I have never received any notice from the respondent complainant. If your honor, if your lordship would see page
Okay,
59,
let notice go at this SS. We'll call for the record.
my lord,
Heard, Mr.
HK Borua, my lord.
Learned counsel for the petitioner. In this petition under section 442, read with section 438 of the BNSS 2023, the petitioner has challenged the judgment and order dated 5/5/2026 passed by the learned session judge Nalbari in criminal appeal number 22 of 2024, whereby the learned session judge has affirmed the judgment and order dated 11/9/2026 passed by the learned Chief Judicial Magistrate Nalbari in NI case number 49 of 2021, whereby the petitioner herein is convicted under section 138 NI Act and sentenced to suffer
Pay a fine of 4 lakhs and in default, undergo imprisonment of 1 year.
sentenced to pay a fine of rupees 4 lakhs as fine amount with default stipulation. Peruse the petition and the documents lesson record. And also peruse the impugned judgment and order dated 5/5/2026 passed by the learned appellate court in criminal appeal number 22 of 2024. And also the judgment in order dated 11/9/2024 passed by the learned Chief Judicial Magistrate Nalbari in NI case number 49 of 2021. Let notice be issued to the respondent returnable in 4 weeks that be taken by speed post and also by usual process within a week from today. Registration call for the record from the learned courts below. Is there any interim there?
There is, my lord, stay, prayer for stay, my lord, page number 14, my lord.
And
The impugned judgment will be stayed, my lord.
having considered the submission of learned counsel for the petitioner and also considering the facts and circumstances on the record, the sentence so handed down by the learned trial court in NI case number 49 of 2021 and also the judgment passed by the learned and being affirmed by the learned session judge in criminal appeal number 22 of 2024 stands suspended till disposal of this petition. And the petitioner is allowed to remain on. You are on previous bail.
Yes, my lord.
He is allowed to remain on previous bail.
Highly obliged, my lord.
So then, but if you know.
May I, my lord?
Yes.
My lord, we are caught in the doldrums of uncertainty in this matter, my lord. My lord, the basic facts of the case is, my lord, there is an account number ending 9702 maintained with AU Bank. That is us, my lord. Now, this account number has been involved in 2 criminal cases, my lord. What has happened, my lord, is that in one of the criminal cases, the Honorable Gauhati High Court has given us a direction that we will have to ensure that a minimum balance of 20 lakhs is maintained in the account. Now, my lord, in another of second criminal case, the Honorable Court of the Chief Judicial Magistrate at Silchar has given a direction to release the money in the other case. Now, my lord, if we comply with the order of the Honorable Chief Judicial Magistrate and release the money from this account, my lord, the honorable order of the Guwahati High Court becomes infructuous. So, my lord, it is only on this that we have come before the court, my lord. My lord, if I can take my lord to Annexure 1, page 32, my lord, that is the impugned order in the case. If I may, my lord. Page 32.
Where is the operative part?
My lord, the second paragraph, fourth last line. Thereafter, this court was. First paragraph, my lord, fourth last line, page 32.
Yes. Yes.
Thereafter, this court was pleased to direct the AU Small Finance Bank to return the seized money to the petitioner as soon as possible. But despite of all such orders, the AU Small Finance Bank has failed to comply with any of the orders of the Honorable Court, my lord. Now, my lord can come to Annexure 2. That is the order of our Honorable Gauhati High Court, my lord. My lord, operative part would start from page 38.
Yes.
If I may, my lord. The petitioner herein is permitted to operate his bank account bearing account number, last four digit, my lord, 9702, opened with AU Small Finance Bank, face so-and-so Mohali branch. However, the authorities of AU Small Finance Branch shall ensure that the petitioner in no way utilizes the amount of rupees 20 lakhs deposited in an account. In other words, till further clearance is received from the investigating agency, an amount of 20 lakhs shall always remain in the bank account of the petitioner. My lord, direction number 3. Direction 2. The petitioner herein, while being permitted to operate the said bank account, is also cautioned from bringing the balance in the said account to below 20 lakhs. In the event the petitioner herein, during the operation of the amount, reduces his balance therein to below rupees 20 lakhs, the authorities of AU Small Finance Bank, face so-and-so Mohali branch, shall immediately freeze further operations of the said account and the liberty granted to the petitioner while this order will not operate further. My lord, my concern as the bank is that I have been directed to ensure that the amount doesn't fall below 20 lakhs, my lord. My lord, by the order of, this is in respect of, my lord, this is in respect of one of the cases in Kachar PS. Now, the issue that we are dealing with is in Kachar PS case number 366 of 2024. The impugned order at Annexure 1 relates to the same bank where a different person is involved in depositing the money. Now, that order says for us to release the amount, my lord. So, my lord, at this time, I'm only praying, my lord, to stay the operation of the impugned order of the Honorable Court of the Chief Judicial Magistrate, my lord. And we call for status from the investigating agencies and the LCR if required, my lord, or we will file it on an affidavit.
Mr. Borthakur?
Yes.
Heard Mr. Khera, learned counsel for the petitioner, and also heard Mr. Borthakur, learned additional PP for the state response. In this petition under section 438 of the BNSS 2023, the petitioner has challenged the order dated 21st of May 2026, passed by the learned Chief Judicial Magistrate Kasar Silsor in Silsor PS case number 366 of 2024. It is to be noted here that by the impugned order dated 21/5/2026, the learned Chief Judicial Magistrate What was the direction of the apex court, Mr. Khera?
My lord, the direction of the apex court, we are not aware of it, my lord. But the order of the Honorable Gauhati High Court has been mentioned in this order. Impugned order, we had placed it, my lord. We'll find mention at page number 31.
The order of the High Court. The order of the Honorable High Court. Page 34.
My lord, that is the order which is for the keeping the money in the account. Now, my lord, the other order for the Gauhati High Court is the direction which they had sought in the impugned order, my lord, in Kachar PS case number 366 for an early disposal within 2 months. My lord, the standard directions of the High Court, Honorable Supreme Court in several of these cases are that only the amount which is in dispute can be frozen and the remaining has to be released. That is the standard direction. But where we stand is, my lord, there are two separate orders. One saying money should be there in the account and the other is saying to release the money. My lord, can come to page 32, stop portion, my lords, the other order of the High Court which has been spoken to.
Okay.
It is there, my lord. It is for the 2 months, the matter to be disposed of.
Okay. The learned Chief Judicial Magistrate was pleased to direct the AU Small Finance Bank to return the seized money to the petitioner as soon as possible. But despite all such order, the AU Small Finance Bank has failed to comply with any of the order of the court. And thereafter directed the AU Small Finance Bank to strictly comply with the order of the Honorable Apex Court immediately. Mr. Khera, learned counsel for the petitioner, submits that the above direction of the learned Chief Judicial Magistrate Kasar Silchar in Silchar PS case number 366 of 2024 is contrary to the direction issued by this court in WPC number 2692 of 2024.
In respect of
2025.
My lord, in respect of Kachar PS case number 5 of 2024.
In respect of Kasar PS.
My lord, para 2 of
the
page
writ
35.
petition of Mr. Khera, writ petition pertains to Crime Branch PS case number 5 of 2024.
Yes, my lord. So this particular account is involved in 2 cases, my lord. So in Crime Branch
PS case number 5 of 2020. Peruse the petition and the documents placed on record, and also peruse the impugned order dated 21st of May 2026, and also the order dated 7/8/2025 passed by this court in WPC number 2692 of 2024. Let notice be issued to the respondent returnable in 4 weeks. However, no formal notice is required to be issued since Mr. Bortakur entered appearance on behalf of respondent number 1, 2, and 3. However, extra requisite copy of the petition be furnished to him during the course of the day. Step upon respondent number 4 be taken by speed post and also by usual process within a week from today. Recessal call for the record from the learned court of learned Chief Judicial Magistrate Kasar. Scan copy of the record. And further, considering the submission of Mr. Khera, learned counsel for the petitioner, and also the facts and circumstances on the record, the impugned order dated
21/5/2026, my lord.
Dated 21/5/2026, passed by the learned Chief Judicial Magistrate in Silchar PS case number 366 of 2024 stands state till returnable date, rest after 4 weeks.
Highly obliged, my lord.
Wait, please, your lordship. This revision petition against the judgment of the learned session judge Dhemaji my lord in criminal appeal number 6 of 26, whereby the learned session judge upheld the judgment passed by the learned CJM Dhemaji in NI case number 65 my lord. My whole contention is that my lord, this appeal has been dismissed by invoking the power under section 425 my lord, summarily dismissed my lord, without going to the my lord.
Is there any bar?
No bar, my lord, but
Then-
procedure has to be adopted, my lord. Only 4 pages judgment, my lord, no discussion, nothing, my lord. If a lordship sees the judgment, my lord, 425 power is there, my lord, for learned session judgment, my lord. But my lord, if your lordship sees the judgment, my lord, my defense was completely discarded, my lord. The appeal complainant case was elaborately discussed, my lord.
Heard, Mr. Punya, learned counsel for the petitioner and learned counsel for the petitioner and Mr. Borthakur, learned additional PP for the state respondent. In this petition under section 442, read with section 438 and 528 of the BNSS 2023, the petitioner has challenged the judgment dated 14/7/2026 passed by the learned session judge Dhemaji in criminal appeal number 6 of 2026. It is to be noted here that by the impugned judgment and order dated 14/7/2026, the learned session judge Dhemaji has dismissed the appeal and thereby upheld the judgment and order dated 24th March 2026 passed by the learned Chief Judicial Magistrate Dhemaji in NI case number 65 of 2024, whereby the learned Chief Judicial Magistrate, within bracket hereinafter trial court, has convicted the petitioner under section 138 NI Act and sentenced him to pay a fine of rupees 4 lakhs with a default stipulation of 6 months imprisonment. Here is the petition and the documents placed on record, and also there is the impugned judgment and order dated so and so passed by the learned session judge, and also the impugned judgment and order dated so and so passed by the learned Chief Judicial Magistrate Dhemaji. Issue notice to the respondents returnable in 4 weeks, to be taken by speed post and also by usual process upon respondent number 1. However, no formal notice is required to be issued to the respondent number 2 since Mr. Borthakur entered appearance and received notice. However, extra requisite copy of the petition will be furnished to him during the course of the day. Recess will call for the record from the learned courts below, and pending further consideration, the sentence so handed down by the learned Chief Judicial Magistrate Dhemaji in NI case number 65 of 2024 and affirmed by the learned Session Judge Dhemaji in criminal appeal number 6 of 2026 stands suspended till disposal of this petition.
Obliged.
IA is for
For suspense of sentence, my lord.
in
Separately.
view of the order passed in this revision petition, IA stands closed.
Obliged.
Made with lordship, my lord. Here, in this case, my lord, 6 months term has been given to the petitioners, my lord, by the session judge Hemren.
3 months, total 6 months. In 2 counts, total 6 months. There was a, my lord, what happened? In the case, my lord, there was land dispute. And the informant and others started following our land. Then there was some protest, and the informant, after the protest, the tractor also fled away, and also the informant. While running, there was sugarcane stems and stuffs, my lord. He fell down and got injured. That is also in the evidence, and also the doctor's evidence also. That injury might have been caused by the stems of the sugarcane. But and there is a lot of contradictions amongst the, my lord, the prosecuting witnesses also. One said both the brothers, the petitioners, came later on. The other said came in on the motorcycle. So, my lord, and dates are also different. When the incident took place, there are two medical my lord, opinions. Both are differ. Both differ to each other. One saying it is simple injury, one saying it is grievous injury, and ultimately, my lord, total 6 months punishment is given. And
Heard Mr. R.P. Sharma, learned senior counsel assisted by Ms.
Edeka.
Learned counsel for the petitioner, and Mr. Barthakur, learned additional wiki for the state respondent. Legality, propriety, and correctness of the judgment. An order dated 17/7/2026 passed by the learned session judge West Karbi Anglong, Hamren, in criminal appeal number 1 of 2026 is being challenged in this revision petition under section 397/401 of the Code of Code of Criminal Procedure 1973. It is to be noted here that by the impugned judgment and order dated so and so, the learned session judge has affirmed the judgment and order of conviction and sentence dated 25/5/2026 passed by the learned Chief Judicial Magistrate West Karbi Anglong Hamren in PR case number 05 of 2022, corresponding to GR case number 24 of 2022, arising out of Theroni PS case number 11 of 2022, whereby the learned Chief Judicial Magistrate has convicted the petitioner herein under section 324, 325, 34 IPC and sentenced him to suffer rigorous imprisonment for a period of 3 months and also to pay a fine of ₹2,000 with default stipulation for the offense under section for the charge under section 324/34 IPC, and also sentence of rigorous imprisonment for 6 months and fine of ₹5,000 each with default stipulation under section 325/34 IPC. 34 IPC. Whereas the petition and the documents placed on record, and also whereas the impugned judgment and order dated so and so passed by the learned session judge in criminal appeal number so and so, and also the judgment and order dated so and so passed by the learned Chief Judicial Magistrate West Karbi Anglong in PR case number 5 of 2022. Let notice be issued to the respondents returnable in 4 weeks. However, no formal notice is required to be issued to the respondent number 1 since Mr. Barthakur entered appearance and received notice for respondent number 1. But extra requisite copy of the petition be furnished to Mr. Barthakur during the course of the day. Step upon respondent number 2 be taken by speed post and also by usual process within a week from today. This is a call for the records from the learned courts below, and till disposal of the appeal, the disposal of this petition, the petitioners are allowed to remain on previous bail, and the suspense on the and the sentence so handed down by the learned Chief Judicial Magistrate. By impugn judgment and order dated 25/5/2026 and affirmed by the learned session judge by impugn judgment and order dated 17/7/2026, then suspended till disposal of this petition. List after 4 weeks.
Obliged, deeply obliged.
May I please note? My lord,
Mr. Ali,
lordship,
this FIR,
FIR case number 11, my lord.
this is certified copy. Can you read it?
We have given type copy, my lord, page 11,
11.
type copy, page 11. Case has been charged, my lord, cognizance taken. Then we filed, my lord, petition for releasing the vehicle, my lord. That was rejected, my lord.
You are the accused in that case?
Loss. My vehicle was hired. I am the driver, my lord.
You are the driver,
Loss.
not the owner.
No, owner and driver.
Owner and driver. Whether that decision will be applicable?
Yes, but on the subject also submitted again. So, in view of the Supreme Court judgment of Lord.
A letter report be called for from the IF. Heard Mr. Ali, learned counsel for the petition. In this petition under section 438 442 of the BNSS 2023, the petitioner has challenged the order dated 23rd June 2026 passed by the learned special judge Borpeta in special NDPS case number 28 of 2026 arising out of Tarabari PS case number 15 of 2026 under section 21B/29 NDPS Act. Notably, by the impugn order dated so-and-so, the learned trial court has dismissed the petition filed by the petitioner seeking custody of the vehicle, being Maruti Suzuki Alto 800, bearing registration number AS01DX1945. After hearing learned counsel for both the parties, it is provided that Mr. Bortakur shall call for a report from the officer from the what report is required if it is solicited? Let the scanned copy of the record be called for from the learned trial court fixing the matter of
27 August.
Obliged.
Item 14.
Well, the other day, Mal cited Niharika infraction.
yes
With
regarding
regard-
crossing.
Madam, I gone through the judgment, madam, but with all respect, madam, it speaks about the interim order pertaining to investigation at the investigation stage. And the petition I have moved, my lord, the investigation is over, my lord. And after going through various judgments, my lord, in Niharika, at paragraph 23, I have a copy. The court has laid down some situations, madam. Paragraph 23, madam, was last.
No, what is your pair in this petition?
Well, we're seeking quashing of the criminal proceeding, madam, on the ground that it has been, the proceeding investigation has been ensured, madam, without taking previous sanction from the district magistrate as required, madam, that I have shown, madam. So, madam. the
No,
whole
previous
proceed-
sanction is required only in respect of the offenses under the Arms Act.
Yes,
Is it only under the Arms Act the search sheet has been submitted?
No, it is not only under IPC also.
Then,
So if the special act is there, madam, apart from the then special will govern, madam.
whether that proposition will be applicable here?
Madam, if there is special act is there, madam, and any not being a special act also, madam, if any section, one section requires sanction, then you
No,
have
no, for the IPC offenses, no sanction is required.
no, I'm explaining a situation, madam. Even if the arms act was not there and only IPC sections were there, and any section under IPC requires a sanction, then sanction has to be taken, madam. Otherwise, the whole proceeding will be null and void, madam. Here, madam, a special special act is there, madam, which calls for previous sanction from the district magistrate. So that has not been obtained, and it is clear from the charge sheet, madam, that no sanction has been obtained.
No, that's all right. For that sanction under the Arms Act,
Ma'am.
the court has taken cognizance of the offenses under Arms Act without sanction.
Yes.
That may be invalid or illegal. But in respect of IPC offenses,
No, madam. Now, if one section requires sanction, madam, then sanction has to be there, madam. Without sanction, madam, whole proceeding will be null and void, madam.
okay. You
And-
produce any decision on this point,
I'm sorry,
if it
madam.
is there.
Madam.
If it is there, produce any decision, will
Yes,
see.
I have already placed my people, the Madhusudan Harijan. madam. Madhusudan Harijan, madam. It should be there in the record, madam. On Monday, I placed it. And Niharika also says, madam, in one of the situation, madam. If I may read, madam, Niharika.
No, not necessary. Yes, Bordhakur?
Well, regarding the point here, This is my prayer because and regarding that part, my lord, I will also have to go to the other laws of the Supreme Court because otherwise, my lord, 302 and other sections of the IPC, according to his submission that if my lord sanction is required in respect of the armed act, then ultimately if sanction is not available, then entire my lord, other my lord, cognizance taken in other sections is also involved. That law, I am not, my lord, I am not agree with this, but that I will also have.
Now, some decisions are there,
Yes.
but I have not remembered it. That for IPC offenses, no sanction is required.
Yes, madam. No sanction. I will also have to clarify.
Okay, then let us fix the matter on Monday or Tuesday. You come prepared. Heard Mr. Monir, learned counsel for the petitioner, and Mr. Bordhakur, learned additional PP for the state respondent. During the course of hearing, Mr. Bordhakur, Mr. Monir has produced one decision of this court. Referred one decision of this court in Madhusudan Horizon versus State of Assam. Reported in Mono GS 0228 of 2001. Mr. Bordhakur learned additional PP submits that he may be granted some time to go for the same. And also to find out any decision of the Honorable Supreme Court, if available on this point. Parallel will list the matter on Tuesday. Monday then.
Monday.
Item 15.
Look, I have filed an additional appeal. Let me take.
At your lordship direction, my lord, I have filed an additional affidavit. Annexing the, my lord, medical literatures.
What is your pair here?
We have to, my lord, set aside the orders, my lord, for framing charges, my lord. The charge was framed, my lord, under section 85, 89, 92, my lord. And the medical report, my lord, negates the same, my lord. Yes, my lord, as per the medical reports, my lord, the abortion was on, my lord, due to nasal, my lord. And FI was lodged on, my lord, 2/11/2025. On, my lord,
This is for causing the proceeding.
my lord.
For causing the proceeding.
Not causing the abortion, my lord. Framing charge, my under section, my lord, 89 and, my lord, 92, my lord. That
No,
was no.
here in the cause title, we have mentioned the FIR, the search sheet, everything.
My lord, my lord, only to, my lord, set aside the, my lord, orders. It is 25 to 26 and 14/5/26. And the fact of the case is that, my lord, on 2nd of my lord, November 2025, FIR has been lost, my lord. And from that day, my lord, she was staying with her parental house, my lord. And, my lord, when she, my lord, examined on 2nd of November 2025, she was everything is right, my lord. And on when, my lord, she was examined on 6/11/2025, there was, my lord, incomplete, the victim incomplete abortion was recorded, my lord. And as per the medical report, my lord, and can have a look, my lord, page 60. I filed a discharge petition, my lord, and without discussing anything, my lord, my lord, discharge petition has been dismissed. And it's also effective. So, my lord, in case of section 89, 92 is absolutely not effective. Yeah, maybe case of, my lord, 85, section 85. Not 89 and 90. The source sheet also, my lord, it is specifically specified, my lord, that
No, the having perused the medical document, you have filed today. Can it be said that these offenses are not made out? Section 91,
89 and 92.
89 and 92.
92. 89 on miscarriage, my lord, 92, my
So,
lord, death of unborn child.
as per this medical report,
My lord.
point number 2, the
Yes.
USG report done on 6/11/2025, the victim incomplete abortion.
My lord. Well, next one, my lord, 3, my lord, point number 3.
Hmm.
On 2nd November 2025, the victim did not complain of pain, abdomen, or bleeding per vagina. So the victim was discharged with medication. And
This pair number 2 of order dated 5/8/2026. Person to order dated 5/8/2026, Mr. Portakur, no, Mr. Khonikor has brought on record the medical document of the victim, injury report of the victim. No, not injury report, medical report of the victim. Victim. What is the same? urge the same. Then also heard Mr. Konikor, learned counsel for the petitioner, and Mr. Bortakor, learned additional people for the state respondent. Issue notice to the respondent for returnable in 4 weeks. Step be taken upon respondent number 2 by speed post and also by usual process within a week from today. However, no formal notice is required to be issued to the respondent number 1 since Mr. Bortakur entered appearance and received notice. However, extra requisite copy of the petition be furnished to him during the course of the day. The SSL call for the scanned copy of the record from the learned trial court. Interim care of the petitioner will be considered on receipt of the report from the record from the learned trial court. List of the 4 weeks.
Diplov.
May I, in this case, I have filed one additional affidavit note, but I have been informed that there is some defect note because the one paragraph which requires the phone number to be given of the petitioner, that was omitted note. So I'll rectify the defect and then
On Tuesday,
my
Kavi. Heard Mr. A. Ali, learned counsel for the petitioner, Mr. Bortakur for the state respondent. Mr. Ali submits that he has filed an additional affidavit, but the same is not tagged to the record on account of some mistake. And he will get the same rectified and he pressed for listing the matter on Tuesday. They are allowed. Thursday.
I'm highly obliged.
Item 18.
May it please your lordship. My lord, the petitioner company lodged an ejahar in 2023 alleging that there has been a fake manufacturing of a bank guarantee by respondent number 4 on behalf of respondent number 5 through respondent number 6, all of whom are from the state of Arunachal Pradesh, Likavali to be precise. Now, from 2023, though the FIR was registered, a PS case was registered, there was no progress in the investigation to the knowledge of the petitioner company. And on approach before the police personnel, the personnel of the petitioner company were told that since the matter pertains to Arunachal Pradesh, therefore the police is finding difficult to conduct investigation into the matter. My lord, as an abandoned question, we filed a CR case in the court of the concerned jurisdiction at Arunachal Pradesh before the learned Chief Judicial Magistrate Pasighat involving the same issue. Now there, my lord, the learned Chief Judicial Magistrate wanted to know the fate of the PS cases since both the PS case was registered. There are 2 matters today. So we approached the police here once again and we came to know that a final report in regard to this particular PS case has already been submitted before the concerned court. And we were told that on the final report being procured, we can submit it before the concerned court where the CR case we have filed is pending. And then the CR case can be pursued with. Now, the final report your lordship will find in the final report that has been laid down at page number 45. This is the typed copy. Here, the final report has been laid down on the ground of there being lack of proper evidence. And accordingly, taking note of the same, this matter was placed before the learned court of the Chief Judicial Magistrate, and the learned Chief Judicial Magistrate accepted that final report and closed the PS case. Now, we applied for the certified copy of both the final report as well as the order of the learned Chief Judicial Magistrate, and then we only came to know that the final report has been submitted on the ground of lack of proper evidence, whereas in our humble contention, it ought to have been on the ground of lack of jurisdiction, because the police out here in Assam, in the North Gauhati, they did not conduct any investigation, but in the final report, that does not suggest so. In fact, in the final report, there are some perverse statements. There are some perverse statements that have been made.
Before acceptance of the final report, you have received notice from
My lord, we were only verbally intimated. We did not receive the notice. We did not even get to peruse the final report. That is also a ground that we have taken in our criminal petition here before this honorable court.
We were under the impression, bona fide impression, that the final report has been submitted as told by the police on the ground of lack of jurisdiction, and understandably so.
No, no. You have been told by whom?
The police, because we were the informant.
You have not received any notice
We
from
did
the
not.
citizen?
We did not get to peruse the final report. There was only a court notice, only to the extent that the final report has been laid down and we need to come on such
No,
and such
therefore,
date.
I am asking you whether you have received any notice from the court before acceptance of the final report.
My lord, notice to appear before the court, but the final report was not before us, so as to come to know that it was on the
No,
ground
no.
of, yes. My lord, we
You have
received,
appeared before the
yes,
Chief Judicial
yes,
Magistrate.
yes.
You
And
have
that is
appeared.
recorded. That is recorded. That is recorded in the order that we appeared, and we even
So
expressed.
you have not inquired why you have been asked to appear before the CJM?
My lord, on that date, it was either for submitting our objection or for submit our or to submit our no objection in
No,
regard to
no.
the final.
Once the investigating officer had informed you that the final report has been submitted,
My lord,
then you ought to have applied for the certified copy or the copy of the same.
my lord,
And
therein
without
that,
obtaining the certified copy, you have appeared before the CJM
my lord.
and you have raised no objection there.
No, my lord. In the order itself, it is there that we have raised no objection, and therefore the final report has been accepted.
Now, how you are aggrieved then?
Aggrieved, my lord, because now after perusing the final report, what we get to say is, my lord, we are not averse to the final report being submitted, but the ground on which the final report has been submitted, it signifies, it
No,
indicates.
under which circumstances the investigating officer will file the final report.
My lord,
That
either
is his prerogative.
my lord, that is
He
his,
will not ask you
my lord.
under what circumstances or under what compelling circumstances he will file the FIR.
Understood, my lord. But my humble contention here is that had this final report, whatever has been stated in the final report, that your lordship will be, my lord, only be able to ascertain once the record comes, to the extent that the police in the final report has said that during the investigation, the place of
No,
occurrence was visited.
Mr. Chakraborty, you say that is a different aspect that we have to call for the record. But the thing is that before acceptance of the final report,
that is
notice
a my
was
lord
issued
mistake.
to you. You have appeared there.
My lord.
And
Your lordship is
you
correct,
have
my lord.
stated that you have no objection.
My lord.
Thereafter, the final report was accepted.
My lord, my lord.
Now
There is some, my lord, slackness on the part of the petitioner company that I humbly admit.
No.
But here, my lord,
As Mr. Chakraborty, you say here you are trying to invoke the jurisdiction of this court under section 528.
528, my lord. 528. Why so, my lord? Because of the fact that on the basis of this final report, the order that has been passed by the learned Chief Judicial Magistrate is to the extent of accepting the final report on the ground of lack of jurisdiction, resulting in page number 50. Kindly for a while, my lord, page number 50. Now, I will be literally, my lord, if I am to use a civil term, I will be non-suited. Here is a claim of 8 lakhs in this case and another case involving 13 lakhs by the petitioner company from the accused. Now, if this is what is to happen, page number 50.
If you have any objection in acceptance of the final report, you could have filed Narazi petition there.
No.
The court would have proceeded.
My lord, that is the, my lord, difficulty that arose. That
now, how can you maintain this petition? How
My lord,
can you invoke this jurisdiction?
My lord,
This is extraordinary jurisdiction.
My lord, inherent jurisdiction in my humble contention, my lord, subject to correction. Your lordship, on perusal of the records, if your lordship sees that in the final report they have said that they have carried out the investigation by visiting the place of occurrence, which is Arunachal Pradesh.
No, now you see, having set aside the finding of the IO, can we direct them that you file fresh this final report assigning this region? Is it possible?
My lord, in my humble contention, if the reason cited by the investigating officer and accepted by the Chief Judicial Magistrate on perusal of the records is found to be perverse, if there is no place occurrence visit, if there is no examination of witness which has been stated in the final report, My lord, my respectful submission, your lordship, my lord, for substantial justice.
No,
In
no,
exercise of inherent powers, my lord, your lordship can go through, because why I'm saying page 50 is the, my lord, prejudice that will be caused. Page 50, your lordship has seen the order of the learned chief judicial magistrate of Pasighat, where, my lord, the learned court over there has taken a note of the fact that in view of the final report that has been laid down for lack of evidence, that very court now finds it difficult to take cognizance of the offense for the same set of allegations, as it would ultimately result to double jeopardy. My lord, with all respect to the, my lord, judicial wisdom of this particular order, we, my lord, thought that now the only alternative that we are left with is, my lord, to come and, my lord, pray before this honorable court that this honorable court at least peruses the records, and it's nothing, my lord, the record is does not have anything else other than, my lord, only the final report, wherein it has been said that during investigation the place of occurrence was visited, witnesses were examined. All these things are perverse, my lord, and we have stated on oath. So, your lordship, as of now, I am not even, my lord, insisting on my lord, issuance of notice to the private respondents. Let the state respondents be put to notice and the record of the concerned police case be called for. Your lordship, my lord, peruses and, my lord, satisfies whether the contents of the final reports, my lord, is per se correct, and if not, my lord, thereafter I leave it up to this honorable court. As of now, my lord,
no,
only thing.
in order to call for the record, you have to satisfy this court that this petition is maintainable. Yes.
Prima facie, it seems that petition is not at all maintainable because he has got the authority to receive notice declared before the trial court for objecting those that final input. And ultimately, after his no objection, that final input was accepted by the trial court. Now, regarding the same facts, considering that order dated page 50, and complaint case that is going on in order project, yet then, my lord, better again approach before the trial court by placing all the complaint petition that regarding this aspect, whether considered by the trial court or not, I don't know. But my lord, that I have already regarding that matter, my lord, we have already filed a complaint case before the Arunachal Pradesh, my lord, before the Pasighat, my lord. So considering all these aspects, although we have, my lord, at that point of time made no objection, but at this point of time, after building all materials, he finds some material, then again he can file a case whether trial court consider or not, my lord, this is a different aspect. But this petition is not at all.
My lord, but the difficulty, what my learned friend is suggesting, my lord, my lord,
No,
all
one
respect.
case is pending before the Chief Judicial Magistrate Pasighat.
That is the only case pending now. That is the only
You
case.
pursue that case.
But that order at page 50, my lord, here the indication is that now that the final report has been laid down on the ground of lack of evidence, the learned Chief Judicial Magistrate Pasighat has observed that it would be difficult to take cognizance of the offense as it would lead to double jeopardy. That is what is at page 50, my lord. Now, because of this order, otherwise there wouldn't have been any difficulty for us in pursuing that matter, because even after submission of final report, there can always be a case made out where the learned magistrate can direct for further investigation or re-investigation. But the learned Chief Judicial Magistrate has taken a view that since here in Assam, the final report has been laid on the ground of lack of evidence, rather than lack of jurisdiction. What the view that was taken was, even I am the conducting counsel in that case also, man. So the view that has been taken by the learned Chief Judicial Magistrate Pasighat is that had this final report been laid on the ground of lack of jurisdiction, since the matter pertains to state of Arunachal
That
Pradesh.
kind of direction cannot be issued.
I understand, my lord, it's difficult, but at the same time, my learned friend's suggestion to approach the court here, where the final report was placed and the order was passed, that is out here. Even there
No,
also,
they are also
difficult because review
criminal
power
court
is
has
not
no
there.
power to review
My
this order.
I am now, my lord, at the mercy of this honorable court, my lord, because
No,
eventually what will happen is my claim of 8 lakhs and 13 lakhs in the other case, that is at item number 20 today. Now this will be, my lord, I'll be literally closed out in terms of any further remedies, my lord.
No, you pursue the case pending before the CJM Pasighat.
Difficult it will be because he has made up his mind that it will.
List the matter on another day for hearing on the point of maintaining.
My lord, 18 and 20, my lord, both same.
Heart, Mr. Chakrabarti, learned counsel for the petitioner, Mr. Porthakur, learned additional PP for the state respondent. list the matter on.
My lord, can it be before? Because the date before the Pasighat court is on 11th of September. Last part of August
11th of September.
is the next date before
Okay,
Pasighat.
7th of September.
7th of September. 18 and 20, my lord, together, take together. 20. Deeply obliged, my lord.
May I approach? My lord,
Yes.
petitioners have come before your lordship against the order whereby NBWA issued against him, my lord. Due to lack of communication with his lawyer, my lord, he could not appear before the trial court. My lord, I want to appear, my lord, some protection, my lord. The next date is 31st of August, my lord. Impugn order, my page 35.
Why you could not appear on that day?
My lord, due to lack of communication, my lord, the lawyer, my lord, who was engaged there, my lord, he did not inform the next date fixed, my lord. And on that day, he also did not take any step.
No, no, was it not your duty to inquire the date from the court?
So, my lord,
The lawyer did not inform you the date,
yes, my
whether you
lord,
have filed any complaint against it?
no, my lord.
No.
No.
What happened?
Yes, well, otherwise, well, initially, well, he was
He was on
he
bail.
obtained the whole bail. Of
He was-
20 to 10, 25. Thereafter, my lord, after filing search sheet, he has not appeared before them.
All along, my lord, the engaged counsel who was taking steps, my lord. His engaged counsel was taking steps on the other occasions, my lord.
Heard.
Last occasion, my lord, he
Mr.
did not take steps. my lord.
M. Ali?
Lord,
You were M. Ali?
my lord.
Learned counsel for the petitioner, Mr. Bartapu, learned additional counsel for the state respondent. This petition under section 528 of the BNS is 2023. The petitioner has challenged the order dated 25/5/2026 passed by the learned special judge Moregaon in NDPS case number 114 of 2025, whereby the learned special judge has issued non-bailable warrant of arrest against the petitioner for his non-appearance. Mr. Ali, learned counsel for the petitioner, submits that the count of miscommunication between the petitioner and his counsel, the petitioner could not appear before the learned trial court on 25/5/2026, and that he is ready to appear before the learned trial court, and therefore he is contented to allow this petition. Mr. Barthabur, learned additional PP submits that the petitioner may be directed to appear before the trial court.
Yes,
But until the next date. When the next date is fixed?
31st August.
31st of August 2026. The petitioner may be directed to appear before the learned trial court on the date fixed, that is 31st/8/2026, and to apply for fresh bail or to allow him to remain on previous bail. Until then, the non-bailable warrant of arrest issued against the petitioner shall be kept in abeyance. Accordingly, having heard the submission of learned counsel for both the parties, this court has carefully gone to the petition and the discussion record, and also perused the interim order dated 17/7/2026. No, 25/5/2026. It appears that on that day the petitioner remained absent without any step. However, taking note of the submission of learned counsel for both the parties, and also considering the facts and circumstances on the record, this court is inclined to dispose of this petition by directing the petitioner to appear before the learned trial court on 31st of August 2026 and to apply for regular bail or to allow him to remain on previous bail. And in the event of filing such an application, the trial court shall consider the same in accordance with law. Till then, the non-bailable warrant of arrest shall be kept in abeyance. Terms of this criminal petition is disposed of.
Obliged.
This motion is registered.
Second 21.
Lordship, the matter may be passed over for the time being, Lordship. Senior is in another court, Lordship.
Second 22.
May I please, Lordship? In this case, my lord, for quashing the my lord FIR as well as the my lord proceeding in PRC case number, my lord. My lord, in this case, what happened, my lord, in the year of 2023, my lord, the son of the informant, my lord, I have made this in this petition, the informant as respondent number 2, my lord. Son of the informant, respondent number 2, was died due to a motor vehicular accident, my lord. And as a result of initially, my lord, the son of the respondent number 2 was sustained injuries and subsequently he was died at hospital, my lord. And out of the same accident, my lord, the petitioner, present petitioner, was also sustained injuries, my lord. But at the initial stage, after registering the case, my lord, the informant as well as the my lord accused person and his family members, my lord, approached before the my lord police officer to withdraw the said FIR, my lord. But the officer in charge of the police station will decline to accept the same, and subsequently charge sheet has been submitted, my lord. And my lord, even thereafter, my lord, the respondent number 2, that is informant, my lord, under the initiative of some local elderly persons, my lord, the matter has been, my lord, amicably settled, my lord. I have, my lord, annexed the one affidavit, my lord, made by my lord respondent number 2, that is page 16, my lord. Page 16. And already, my lord, one motor vehicular MSC case has been filed, my lord, and that case has also been disposed of, my lord, in National Loko Adalat, my lord.
Well, let the record come, we will see.
My lord.
We will issue notice. Heard, Mr. Ahmed learned only for the petitioner, Mr.
Notice may go, my lord, in the meantime, my lord.
Learned additional PP for the state respondent.
Yes.
In this petition under section 528 of the BNSS 2023, the petitioner has filed for quashing the FIR of Soigao PS case number 208 of 2023 under section 279/304 AIPC. And the proceeding of PRC case number 1042 of 2024 pending before the Court of Learned CJM Kamrup M. Amingao. Mr. Ahmed Learned Counsel for the petitioner submits that the petitioner herein and the respondent number 2 have settled the matter amicably, and they have also informed the same to the officer in charge of the concerned police station. No, to the investigating officer of the said case, but the investigating officer has submitted charge sheet against the present petitioner. And that in connection with the said accident, the respondent number 2 herein has filed one MSC case. Being MSC case number, what is the number?
My lord, MSC case number, my lord, 1060/23, my lord.
1060 of 2023, and the same has been compromised in
Disposed of
National Lok Adalat in the year.
MSC case number 1060
In
of
the year when the National Lok Adalat
or
was held.
in, my lord, National Lok Adalat order dated 8/3/25, my lord.
8/3/2025. And that the respondent number 2 is not willing to pursue the case in PRC case number 1042 of 2024, and she has also filed an affidavit before this court. And as such, he has contended to allow this petition. The submission of Mr. Ahmed, learned counsel for the petitioner, needs further consideration. At this is a notice be issued to the respondent, returnable in 4 weeks. State be taken upon respondent number 2 by speed post and also by usual process within a week from today. However, no formal notice is required to be issued to the respondent number 1. Since Mr. Borthakur entered appearance and received notice, however, extra requisite copy of the petition be furnished to him during the course of the day. Registrar call for the record of PRC case number 1042 of 2024 pending before the Court of Learned Chief Judicial Magistrate, Kamrup Amingaon. And further, considering the affidavit filed by the informant, filed by the respondent number 2, and also considering the submission of learned counsel for both the parties, it is provided that further proceeding of PRC case number 1042 of 2024 pending before the learned CJM Kamrup and stands state till returnable date list of the 4 weeks.
Obliged, my lord. Much obliged, Lordships.
May I please, your lordship? The petitioner hearing, your lordship, who is a lady, your lordship, has opened the proceeding PRC case number 278 of 2026, your lordship. Essentially, your lordship, there is an FIR, your lordship. Your lordship will get it at page 19. Page 19 is the FIR, your lordship. May I read, your lordship?
Not necessary.
Lordship.
At
what
what
has
stage the
happened, your
proceeding
lordship?
is pending now?
Lordship,
It is in investigation stage or?
no, your lordship, charge sheet has been filed, PRC case has been registered. Now, she was not aware about this, your lordship. When she, your lordship, she is now a resident of Australia, your lordship. Yeah, her husband is an Australian resident. She applied for citizenship there. Here, your lordship, from the police concerned police station, they are required to, your lordship, get a no objection certificate or a no criminal record certificate, your lordship. When they applied for that, your lordship, she could come to know about the pendency of this case, your lordship. And in fact, what has happened, your lordship, directly she has nothing to do with this. Her husband, your lordship, who is here for long-term visa for medical purposes, kidney disease, your lordship. Now he, after her marriage with him, your lordship, he obtained, your lordship, Aadhaar card and PAN card, your lordship. Based on that, your lordship, he applied for passport. Passport was ultimately rejected. He left for Australia, your lordship, again, your lordship. Passport was rejected on the ground that he has already having a passport in Australia, your lordship. Now, while applying for this, your lordship, Aadhaar card and PAN card, her house is shown as, your lordship, place of residence, your lordship. And that's why probably this case has been registered. And directly she is not involved in the matter. Your lordship may call for the case record. I am not also praying for an interim direction, your lordship. And it be heard, your lordship, at a short date, your lordship, after receipt of the record.
Heard, Mr. Borthakur. Learned senior advocate, assisted by Mr. Learned counsel for the petitioner and Mr. P. Borthakur, learned additional PP for the state respondent. In this petition under section 528 of the BNSS 2023, the petitioner has tried for setting aside the FIR of Gulaghat PS case number 174 of 2026, registered under section 319, which will make it 2, 318, which will make it 4, 336, which will make it 3, 340, which will make it 2 of BNS 2023, reduced section 12, which will make it B of Passport Act 1967, as well as the charge sheet number 103 of 2026, dated 26/6/2026, And the proceeding of PRC case number 278 of 2026 and the order of taking cognizance dated 29/7/2026. Here is the petition and the documents plus in the record. Let notice be issued to the respondent returnable in 4 weeks. However, no formal notice is required to be issued since Mr. Borthakur entered appearance for the informant is in binding.
Informant
Can
is
you
also-
represent him?
He can take probably. He is a sub-inspector of police.
Yes, second.
No formal notice is required to be issued since Mr. Borthakur entered appearance for both the respondents. However, extra requisite copy of the petition be furnished to him during the course of the day. Basis will call for the record from the learned trial court. Please the matter.
First
On-
week of September. or so, when they-
Correct.
14 September.
Lords.
Item 52.
Brief your plan.
May it please your lordship. Lordship, in this matter, we are challenging an order by which a search and seizure warrant was directed to be issued against the present petitioner, lordship.
Caesar.
Yes. Search and seizure, lordship.
Search and seizure.
Lordship. In in a case, it is a case registered under the Domestic Violence Act, lordship. What had happened, originally the respondent filed a petition, and lordship may see the prayers that she had in the petition, lordship, at page number 34. At page 34, the top part, under the above, the aggrieved person phrase, to pass an order restraining the respondents not to interfere in the possession of the aggrieved person in respect of the scheduled rooms of the shared household, to pass an order of compensation directing the respondents to pay 10 lakh each, and for protection order prohibiting the respondents from causing domestic violence. So there was no prayer for lordship recovering of the Sridhan articles. However, in the same page, she mentions certain Sridhan articles, lordship, on the lower end of that page. And the next page as well. This
Page
petition,
number
34 itself, lordship,
34.
the lower part of the page, lordship.
Yes.
He mentioned this petition, lordship, was not accompanied by any verification or affidavit, lordship. We filed a written objection, and then the matter proceeded directly for evidence, and she filed her evidence on affidavit also. However, there was no documentary evidence showing that she owned any of the articles, lordship. We have filed our objection, objecting that all of these articles do not belong to her. In any case, lordship, she filed a supplementary petition, lordship, at page number 70. After 2 years of institution of the case, lordship, page number 70, if the honorable court kindly sees para 5 at that page, lordship, the last para of that page 70, that though the list of Sridhan articles were given in the main petition, but due to inadvertent mistake in the prayer portion, it was not prayed to return the Sridhan articles, and as such, this petition be treated as part of the main petition, lordship. So she also have either filed an application for amendment of the main petition, but she did not do that. She directly filed this petition, and there is also interim prayer, lordship, in this petition, that she is asking for a direction to return these Sridhan articles, lordship. Again, it is accompanied by an affidavit, but however, at page 72, lordship, there is no oath in the affidavit. There is no oath in the affidavit. These are curable technical defects, lordship. This was filed on 35/2026. The corresponding order is at page number 73, lordship. Today, by petition so-and-so, the aggrieved has prayed for recovery of Sridhan articles which are lying in the house of the respondents, and also to consider this petition as part of the main petition. Cost of rupees 500 has been deposited with the received by the aggrieved. The learned counsel representing the respondents has verbally prayed for fixing a next date for cross-examination of the aggrieved. Considering the hardship borne by the aggrieved, this court is of the opinion to give a last chance to the respondents for cross-examination of the aggrieved, else the court will proceed according to the procedure of law, fixing 4.6 for further cross-examination of PW1 and hearing on petition number so. No opportunity to file any objection against the petition, Lordship. On the next date, the next page is the next order, Lordship, 4/6/2026. We filed three petitions on that date, Lordship. We pointed out the technical defects in the main petition and as well as the evidence on affidavit and also the petition for Sridhar. Saying that this is not according to law. There is no oath, there is no verification, and the affidavits are not proper.
No, the question is whether the petitioner in the domestic violence case
Right.
is whether the list of properties given in page number 17
Lordship.
are the street on or not.
To that extent, there are some articles which are hers. We are ready to return those, but however, she has stated additional articles which are not all hers. And she's saying gold ring and something are hers. There, she's saying there's a fridge which is because I am living in a joint shared household, Lordship. My parents are there. My brother-in-law, my sister-in-law is also there. So already we had a fridge, we had an inverter. Now she has claimed everything there. We have not gotten a chance to object to the petition. Directly, it was fixed for hearing, and on this date, when they were hearing on the objections, kindly see the last part of page
No,
number
that's
7.
all right. You go and approach the trial court.
The search and seizure
Thanks
warrant.
for granting you time to file objection there.
Lordship, Lord. That is all we want.
So you see, in this petition, can we determine which article belongs to whom?
No, Lordship. I am
Then?
saying the learned trial court at page 81 has issued a search and seizure warrant against me, which under the provisions of the Domestic Violence Act, the police cannot be.
Why don't you return the articles belonging to her?
I will return, Lordship. That submission may even be recorded. But the police should not come and take it, Lordship, because I am also a doctor. She is a doctor serving
No,
under the
maybe
doctor.
before the police entering into your house, you hand it over to her.
Police already came on 10th, Lordship, after for the warrant, for executing the warrant, and we asked for some time, and they said they will come again on 16th, day after tomorrow. That is why we have come with this urgent petition. And even the main petition, the learned trial court said you cure the defect in the petition first. Without curing the defect, they have not cured it yet, but this order was passed.
No, forget about the defects.
Lordship.
What you have submitted are the technical defects.
Lordship. But the seizure and search and seizure, the section 19, subsection 8 says I can be directed
So
to
you
return.
see, the petition number 695 of 2025 was filed long back.
No, it was
Before the
filed on
order dated 4/8/2026 being passed.
Lordship.
So you got ample opportunity to file objection there.
Lordship, I have annexed all the orders in the meantime. Whatever the orders were passed, we raised an objection as regards the entire case. The learned trial court said these are curable defects. But that defects were directed to be cured, Lordship. By page number 78 is the operative portion. But subsequently, there are two orders, and directly the case was fixed for necessary order without hearing on that petition. An order was passed.
No, in respect of the petition number 695 of 2025,
Lordship.
you have been heard. You are represented by your counsel.
No, Lordship. Kindly see after filing of the petition, the next date is 35/2026. We filed 3 different petitions regarding procedural defects, those technical defects. Those were completely
It seems that you are not interested to return those articles.
No, Lordship. I'm saying the police should not come and take it. That jurisdiction is not provided under the PWDBL. At best, the protection officer can be asked to go and take the articles. whatever is hers, Lordship, I am willing to give her, but kindly give us an opportunity to object.
No, again, why should we grant you time to file objection?
Because the learned
have
trial
already been
court has not
granted.
given. The learned trial court said that you cure the defects. But she did not cure the defects, however, the order was passed. First date it was fixed for hearing, next date for necessary order.
So this impugn order suffers from no infirmity. Why should we interfere?
No, Lordship, because one, I have not been given an opportunity to hear on this petition of Sridhan. Secondly, Lordship, the previous order, the learned trial court said you cure the defects in the main petition as well as the Sridhan petition and the evidence on affidavit. That defect she never cured because she remained absent on the next day. And on the date thereafter, this petition was.
No, direction was to the executing officer
Of the warrant.
execute the warrant.
Yes, Your Lordship. And recover the articles
Is
which
the
are
direction
mentioned.
was issued to the police?
Yes, Lordship.
Yes, OC.
Yes,
OC
Lordship.
of concerned PA.
Yes.
So is there any other authority to execute the search warrant?
Your Lordship, if I may read from the Domestic Violence Act once, Lordship. The direction that the learned trial court can pass is provided in section 19(8). If I may read, that the magistrate may direct the respondent to return to the possession of the aggrieved person her stridhan or any other property or valuable security to which she is entitled. So I can be directed to return the articles. If I do not comply, there is another provision, Lordship, under the rules. Under Rule 10C, Lordship. Rule 10 says the protection officer, if directed to do so in writing by the magistrate, shall, subclause C, restore the possession of the personal effects, including gifts and jewelry of the aggrieved person and the shared household to the aggrieved person. So whatever Sridhan she has, if I am not returning to her, the protection officer can be directed to go and take it and restore the possession, Lordship. But police, nowhere there is provision that police can be directed to search in my house and seize the property and give it to her.
When the petition was filed under the Domestic Violence Act?
2023, Lordship.
23. And since
October.
then you have not been returning the articles.
No, she did not pray, Lordship. She herself admits in her last petition that there was no prayer.
Read with section 442 of the BNSS 2023. The petitioner has applied for setting aside the impugn order dated 4/8/2026 passed by the learned subdivisional judicial magistrate as Dorong Mongoldoy in Miss case number 279 of 2023. It is to be noted here that by the impugn order dated 4/7/2026, the learned subdivisional judicial magistrate advocate S. Dorong Mongoldoy in Miss case number 279 of 2023 has allowed the petition number 695 of 2025 filed by the respondent herein. Where is the impugned order?
Lordship, page number 81.
To issue, directed to issue search warrant for recovery of the articles mentioned in the petition number 695 of 2026, and to hand over custody of the same to the respondent hearing on execution of Zimma bond of rupees 30,000, and also directed the officer in charge concerned police station to take all the needful action for execution of the search warrant. Mr. Dale, learned counsel for the petitioner, submits that learned trial court, without affording an opportunity to the petitioner to file objection, and in contravention of the rule, what is the rule you have referred to?
Lordship, Rule 10. 10C. 10F also provides when the assistance of police can be taken. It is only for confiscating any weapon involved in domestic violence.
Rule 10F.
10C for protection officer is permitted to restore possession of the personal effects, and protection officer 10F says protection officer can take assistance of police.
10C.
10C, Lord.
10C. 10C. And as such, the impugned order is illegal and arbitrary, and therefore he is contented to interfere with the same. Having heard the submission of Mr. Day, learned counsel for the petitioner, this court is inclined to dispose of this petition by directing the petitioner to file a petition before the learned trial court, raising his grievance for not affording an opportunity of filing objection in the said petition, and also raising objection under Rule 10C of the rule, and on such petition being filed, the learned trial court shall consider the same in accordance with law. Until disposal of the said petition, the order, impugned order dated so and so stands state. You go and file application there.
Most obliged.
May I be? My lord, in this case, I have to challenge the, my lord, impugned order, annexure 8, page 32. Whereby, my lord, so the order dated 27 to 26, Lord, NBW will issued.
Where is the impugned order?
Page 33, my lord, last page. Petitioner is, my lord, nowhere connected with the alleged offense, my lord, but his name has been dragged. He is not in the name in the FIR, my lord, but his name is dragged.
No,
yes.
we are not concerned
Yes,
with that. Why you could not appear before
Because
the trial court on 28/7/2020?
my lord, he was not properly served about the, my lord, summons, my lord, earlier. And he was not also, my lord, locally, he was for his livelihood, he remains in Meghalaya, my lord. And having come to know about this, my lord, he has thereafter immediately come, my lord. This is the only reason. Will appear in the next statement. Yes, after the filing of the charge sheet, my lord, he has approached this session court, my lord, but the due to the filing of the charge sheet, his bail was not taken into consideration.
Your petition was rejected.
Yes, Lordship. On appearance, he will apply for my lord regular bail.
Heard Mr. Prokesto, learned counsel for the petitioner, Mr. Portakur, learned additional PP for the state respondent. The order dated 28/7/2026, passed by the learned Chief Judicial Magistrate, Sirgomi, in PRC case number 1438 of 2024. Arising out of Ratabari PS case number 117 of 2024, is challenged in this petition under section 428, read with section 442 of the BNSS 2023. Mr. Purkesto, learned counsel for the petitioner, submits that the petitioner is the accused in the aforementioned case, and that the said case was surseated without there being any involvement of the petitioner with the offense alleged in the affair, and someone was not properly served upon him, and thereafter by order dated 28/7/2026, the learned trial court has issued non-bailable warrant of arrest against him. And he also submits that the petitioner is ready to face trial and will appear before the learned trial court on each and every day, and therefore he is contented to allow this petition. So by filing the anticipatory bail application,
Yes.
you are aware of that one case is pending before
Yes, yes.
against you before the trial court.
Yes, but after when the trial started, my lord,
So then where is the question of serving of notice upon you, summon upon you?
but when the trial took place, my lord, after filing of this, my lord, charge sheet, he has filed the bail, my lord, and after.
After hearing learned counsel for both the parties, this court is inclined to dispose of this petition by directing the petitioner to appear before the learned trial court and to apply for regular bail. And in the event of filing such an application, the learned trial court shall consider the same in accordance with law till the non-bailable warrant of arrest issued against the petitioner shall be kept in abeyance.
Obliged.
Other numbers 46 and 47.
Item number 46, Lordship. We need to take steps, Lordship.
You inform the other side.
Lordship, I have informed my senior. He told me he will inform.
Mr. Ahmed, you are here.
I will condemn petition.
So morning he has applied for an adjournment of this matter.
No petition they have filed, I have no. I file a condemn petition. Thereafter, that is the condemn petition first. 6/2024.
Are you a party in this review petition, Mr. Ahmed?
My lord.
You are a party.
Yes.
Oh, respondent
But I
number?
am
Not a party. Heard, Mr.
D. Kolita, Lordship.
Learned counsel for the petitioner. Office note dated 28/7/2026 indicates that no step is taken by the petitioner for issuance of notice to the respondent number 6 and 7 till then. And he submits that he may be granted some time to take a step upon respondent number 6 and 7. Here allowed, less the matter after 4 weeks, step be taken by speed post and also by usual process in a week from today. Any respondent in the review petition?
Yes, sir.
You are for?
Secondary revision, Lordship.
Takoria for secondary education.
Yes, sir. And 7 I was, but notice not.
No, no, in a review petition, are you a party?
They made party, resolution number 7.
You are for respondent number 7.
Because representation filed by me. And that
Okay.
order has to be reviewed.
However, Mr. Ahmed submits that he has the instruction to appear on behalf of respondent number 7. You have filed your color number here.
But one time I am now just appeared.
Okay, and he will be
One time I
filing
will,
his power.
that case I will, if they have the copy, I will actually lodge it in liquidation lodge it. He is the private respondent lodge it. Till now notice has not been served lodge it. And,
Okay, now if he has
yes,
instruction,
if they
that
serve
will
me copy, I will file local
he will file local number within a period of 1 week from today. The learned counsel for the petitioner shall furnish a copy of the review petition to Mr. Ahmed during the course of the day. List the matter after 4 weeks. You have to take step upon respondent number 6 now.
Now, quantum matter you lost the quantum.
Yes.
Here is specific direction.
You are for the petitioner here.
Yeah. Page 17. Paragraph 16.
No, Mr. Ahmed, you say, since a review petition is filed, so without being disposed of the said review petition, can we go to this contempt proceeding?
Well.
First, let us dispose of this matter and thereafter this contempt petition.
Sometimes I got a glove, I can tell you glove was good.
Okay. Registrar list this contempt petition along with item number 46.
48.
May I please? Lord, in this case, the petitioner took steps, Lord, and so far as the track consignment report is concerned, Lord, it says that the notice was delivered to her. The next date, your lordship will find that item delivered on 22/6/2026.
Heard Mr. Ali, learned counsel for the petitioner. Mr. Ali today produced one track consignment report which indicates that notice upon the respondent was delivered on 18/6/2026.
My lord, delivered on my lord 22/6. I have highlighted, my lord, the second page below, my lord. Delivered on 22/6/2026.
Delivered on 22/6/2026. But the respondent remain unrepresented today. Accordingly, this court is inclined to engage on amicus to represent the respondent. (28) Accordingly, Srimati Aforesaid Rana is appointed as amicus to represent the respondent. Justice shall reflect the name of Srimati Aforesaid Rana for the respondent in the cause list and also furnish the relevant papers to her well in advance and list the matter on.
My lord, I will seek for a short date, otherwise not warrant has been issued against me.
Okay, sorted.
My
25.
I'm obliged.
Not yesterday we filed our Wakalat, we are praying some time to file our affidavit.
Okay. Heard Mr. Ali, learned counsel for the petitioner, and Miss learned counsel for the respondent. Miss Dave submits that. Mr. Bortakar, we were here for the respondent number 1. For the respondent number 1. Mr. Dave submits that she may be granted some time to file objection. Fair allowed, list the matter. When?
August 27.
Till then, well, the further proceeding may kindly be stayed. Lord, you kindly see the FIR, my lord.
Let
294 case.
let them file their objection, thereafter we will be
Lord.
considered. We will
Basically,
consider your pair.
Basically,
Interim pair of the
294.
petitioner will be considered on next date.
27 August. There is 31.
May please. It's a regular bail application. The petitioner is in custody for 136 days, my lord. In this case, day before yesterday, my lord, co-accused was granted bail by this honorable court. The lordship will find the FIR at page 11, my lord. Page 12 is the relevant part. Initial page 12. my lord.
Page number
12, my lord. Perhaps the other file has been given. Lordship has it, my lord. Lordship has the FIR, my lord. Now, in this case, the co-accused from the initially police on suspicion went to the co-accused Sujit Das, my lord. Sujit Das led the police to the petitioner, and from the possession of the petitioner, my lord, 2.7 kg of ganja was recovered, my lord. Initially 2.5 kg in his house and 0.182 kg from his kitchen, my lord.
no, here you see from the allegation in the FIR,
My lord.
you use that person for peddling the drugs.
Yes, my lord, that is the allegation, yes, my lord.
Hmm?
So, my lord, in this case, this amount of money was, this amount of ganja was found, intermediate quantity. And my lord, 2,96,000 rupees was also found from my possession, my lord. That is the allegation, my lord. Now, charge sheet has been submitted, my lord. Out of 7 witnesses, 2 witnesses have been examined, my lord. As far as the contraband quantity is concerned, my lord, that is intermediate.
No, that's
27
alright, but,
capital A is there, my lord. But for 27 capital A, my lord, there has to be financing, my lord. So there has to be some material to show that I am financing the drug trade, my lord.
that is the subject matter of trial.
But there is no allegation, my lord. There is nothing on the record to show that I am financing the drug trade, my lord.
No, charge is also framed under section 27.
Yes, my lord. The charge was also framed, my lord, against the co-accused also, my lord. Your lordship is pleased to grant the co-accused bail, my lord.
No, co-accused is that is a different aspect.
Yeah.
Nothing was recovered from his possession. What was recovered
My lord, 2.7 kg of ganja, my lord.
from your possession?
From my possession, my lord. An amount of rupees 2,96,000. But charge was framed, my lord, under 21B to B, 27A and 29. So financing allegation is, my lord, against both this petitioner as well as the co-accused, my lord. From the
Maybe you were not standing in the same pedestal with the other
Yes,
accused.
my lord. My lord, I admit, my lord. Because from him, nothing was recovered. From me, contraband was recovered, my lord. But my only submission before your lordship is that if there is no material to substantiate this financing element, my lord, 27
No,
may not be there.
At this stage, we cannot determine that
Yes.
issue, whether you have financed it or not. Charge is framed against you.
Yes. Well, my-
So unless the prosecution side is given an opportunity to adduce evidence
Yes.
in support of that search,
Yes.
if we record a finding to that effect, it will cause serious prejudice to them.
My lord, I agree, my lord. But
Mm.
my only respectful submission is that, my lord,
Mm.
there are two components of this case, my lord.
Mm.
One is the recovery of the contraband and one is the financing element. Now, for a recovery of contraband, I do not stand in the same footing as the co-accused, my lord, because
Mm.
from him nothing was found. But the financing allegation is against both persons, my lord, both the co-accused as well as me, my lord.
Mm.
If your lordship will kindly see the FIRs, prima facie, my lord, it is made out.
No, no, you say
Mm.
recovery of this a huge amount from your position.
Yes.
What it would indicate?
My lord, money is found in my possession,
Mm.
but financing involves that I have to give money to somebody.
Mm.
So if I have money in my possession, my lord,
No, financing does not mean that you have provided finance to him.
my lord, in that case, may I pray, my lord, now two witnesses have been examined. Prosecution may examine two more witnesses, my lord, in that case, perhaps. In that case, your lordship may.
Yes,
be
Mr. Borthakur?
Yes, but otherwise regarding those statement of the witness,
Mm.
there are materials against the accused, but he is involved in finance. Regarding others, so well, there is nothing found in his position. There are statement of the two witnesses, Rana Mazumdar and one other major, and other witnesses also. He is the person, my lord, present petitioner. He is involved in, my lord, allowing, he, my lord, use all other persons to, my lord, for selling all these drugs.
Mm.
Thereafter, finding allegation under section 27A, my lord, search the accused. Initially, although search was framed on 21/5/26, that is, my lord, wrongly under section C. Thereafter, my lord, search altered to 24/6/26, and now, my lord, section is under section 27A, 29, and 20B to B. So, my lord, there are materials I have trademarked, my lord, the statement of the witnesses, my lord. And, my lord,
Regarding financing part.
yes, but regarding financing part, a huge amount of money, my lord, recovered thereafter, my lord, from his shop also, my lord, being pleaded by the accused person, not only from his house, from his shop also, my lord.
No, no, whether the witnesses so far examined
Yes,
implicated him with that offense.
yes, but they have stated that one of the who needed the accused, the other police, they also stated he is the person who may involved in allowing all these foodies, my lord. They only test foodie, my lord, for supplying all these to a particular area. They are in fact peddling
Yeah,
evidence.
let it be after some days.
My lord.
Let the prosecution side examine some more witnesses. After hearing learned counsel for both the parties, it is provided that recessal is the matter after 4 weeks.
My lord, kindly fix a date.
Then
my lord.
recessal also call for the up to date
Yes.
scan copy of the record.
16 September.
16th, my lord. Deeply over.
To be spoken, so I can 50.
Make it up, lordship. In this case, during the presidency of the three persons died. Then there was as a ending sub. Yesterday,
Pardon?
three persons died.
Uh,
During the presidency of this case,
uh.
three persons have died.
Thereafter?
The Tanachari Boro, Ita Boro, and Komor Boro died.
Mm.
During the presidency of this,
Mm. Thereafter?
no any IA is registered.
Who died?
Died Tanachari Boro, Ita Boro, and Komor Boro. Under the provision of the
Rita Boro, Sita Boro, and Anand Boro.
Lordship, Tanachari Boro. Mr. Mrs. Gita Boro and Mr. Komal Boro. The two son, one son died,
No, Anand Boro already died.
but Kaneshwari Boro already died. Gita Boro and Komal Boro. No any IA raised that as for the provision of the law, the High Court, there's a procedure to raise that IA, not this raise that. As per the provision of the
No, Mr. Talukdar.
Yeah.
You see, by order dated 30/10/2025, name of respondent number, no, appellant number 1 and 5 were struck off. 1 and 5.
one,
One is Thaneswari Boro and 5 is Komal Boro.
the Komal Boro.
Yes.
On an oral submission. No any IA is raised. Oral
Maybe.
submission. There is no any proof.
No, maybe. But this court has allowed the pair. Their names were struck off.
Then Gita Boro also died.
When?
No, actually, I am the opposite. But I do not look into it, but that is it. He already died.
The remaining legal heirs are alive, my lord. Only 1 and 5 died with their name was struck out. The remaining legal heirs, my lord, 2, 3, and 4, they are alive. Only 1, because her heirs are already on record, that is why respondent number 1 has struck out. And appellant number 5, he died without any legal heirs, my lord. That is why his name was struck out. 1 and 5.
The 2, 3, and 4 are alive.
Alive. 2, 3, and 4 alive.
Okay.
No, I know. 3 persons are there. Total 3 persons are there. Yeah. That if necessary, they may be appear personally appear.
Oh,
Because Gita Boro, if
you are the person representing them.
no,
Are you not their engaged counsel?
no, the 3 persons.
Is it not your duty to apprise them if anybody, any person during the pendency of this petition died, to inform them?
No, it is the duty of the
No,
appellant.
it is also your duty. So this Sita Boro has not suffered demise. She is
No,
alive.
she is alive. Sita Boro, Rita Boro, Ananda Boro, they are alive.
They are alive.
They are alive.
Okay.
Ananda Boro, Rita Boro, Sita Boro, they are alive. But another 3 persons already died.
No, altogether 5 respondents were there. Out of 5, name of 2 respondents were struck off. They are respondent number 1 and 5. And 3 are alive. Sita Boro, Rita Boro, and Ananda Boro.
Gita Boro also died. As per instruction from my client, Gita Boro also died.
You produce the relevant documents then.
No, how can they will not produce the opposite party? They will not produce.
No, it is your information. You substantiate your information. You produce any document, death certificate. Produce it. It is your contention that she suffered demise. So it is your burden. You have to establish that the person died.
Your lordship, it is very difficult to produce any document from.
Then we will pronounce judgment. We will list the matter on Monday for judgment.
Hello.
Number 33.
It relates to the
Matter relates to the POCSO actually.
Pardon?
Someone will appear, Lordship, just after some time he asked me about the case, Lordship, on behalf of the information.
Morning time, we have also. All of the, get notification, regarding the starts of notice.
Just after some time, Lordship, someone asked me to appear on behalf of the.
Okay, after some time.
Okay.
34. Please off. My lord, the associated matter, my lord.
Yes.
In fact, the petitioner is,
And on behalf of respondent number 2, I have not received any copy. Last order, it was directed to.
You have not furnished any copy to him.
in fact,
Copy
my
of the
lord,
petition?
in fact, my lord, somebody, my lord, asked me, my lord, and I just inquired into the, my lord, who is the person, then I could not find anybody to serve the copy.
No, Lordship.
There is a-
Furnish him today.
Yes, yes.
We'll list the matter on copy. Heard Mr. Bora, learned counsel for the accused. Mr. Goswami for the respondent number 1 and Mr. R. Mandal, learned counsel for the respondent number 2. Mr. Mandal submits that he has not been furnished with a copy of this application. Mr. Bora, learned counsel for the accused, undertakes to furnish a copy of the same during the course of the day. Recessal is the matter on what? Thursday. Thursday.
35.
May I please, your lordship?
Yes.
Some time may be granted, your lordship. We want to file an additional affidavit, your lordship.
Additional affidavit for?
Lordship, Honorable Division Bench has passed a judgment regarding this non-compliance of section 36 of BNSS day before yesterday, your lordship. I have to go through the judgment thoroughly also, and regarding the seizure, time of seizure and his production before the magistrate, lordship, I have to obtain certain instruction and have to file that affidavit, your lordship. Only day before yesterday, your lordship.
So how that judgment will help you?
Lordship, in this matter, we have taken the plea of non-compliance of section 36 of BNSS, your lordship.
In which paragraph of the application you have taken that place?
Lordship, para 5, your lordship, page number 5.
Okay. On the pair being made by Ms. Hussain, learned counsel for the accused. This matter stands adjourned to be listed in the next week.
Lordship, similar matters are fixed on 26th, your lordship.
26, okay. 26. Okay. On that day, Mr. Porter shall produce the case before the court.
Deeply obliged, your lordship.
36.
Today's fixed for service.
Service completed. So no one entered appearance. It's POCSO matter.
Yes, my lord.
Heard means Burman, learned counsel for the accused. Mr. Goswami, learned additional PP for the state respondent. Mr. Goswami appraised this court that service upon respondent number 2 is completed, but no one enters appearance on the behalf of the respondent number 2. In that view of the matter, okay. Sri Sanjay Kumar Chakraborty be appointed as amicus to represent the respondent number 2. Rest shall reflect the name of Sanjay Kumar Chakraborty in the cause list and also furnish the case papers to him during the within a period well in advance and list the matter on 24th 24.
Obliged.
May I please, Your Lordship? So this was basically a land dispute, my lord, which arose. And my lord, there was some sort of scuffle. Initially, we lodged an FIR, my lord, that has also been charge sheeted. And my lord, the FIR which was lodged against us, my lord,
Scan copy was called for, received.
the
So
second
what are the
case,
punishment prescribed for the
my lord, it's with my lord, murder, my lord, 103, my lord. 103, the person died, my lord. And my lord, it was, my lord, it was basically, my lord, an attack which was made on us, my lord. On self-defense, there was some, my lord, retaliation from us. And lordship will see, my lord, in the charge sheet that was, my lord, submitted. We had filed the, my lord, lodged the FIR earlier. That charge sheet also we've annexed, my lord. All of them are absconding, and my lord, there are, lordship will see at page 87, my lord, the relevant part. This is the FIR we lodged, my lord, on the basis of which, my lord, 85, my lord, onwards, my lord. They were the, my lord, persons, my lord, who entered, my lord, our campus with dangerous weapons, my lord.
How long here?
My lord, 87, lordship will see, my lord, that they are, all of them have been, my lord,
No, no.
against charges
Doctor,
against all of them.
How long you were behind the bar?
My lord, 115 days, my lord.
115
days, my lord. And on the, my lord, the charge sheet records that I have confessed, my lord. On the basis of that, my lord, the charge sheet has been submitted, my lord, on the basis of confessional statements purportedly made by, my lord, me, my lord, that I had hacked this person. And, my lord, FIR, of course, my lord, was that, my lord, we had entered, my lord, there was scuffle, my lord. Page 15 is the FIR, which was lodged by them, my lord. They're all absconding, my lord. With most respectfully.
No, at what is this? The case is pending now.
My lord, my lord, in both the cases, my lord, yes, my lord, NBW has been issued with regard to the absconding person.
Appearance is this.
My lord, appearance, my lord. Sorry, my lord. He surrendered, my lord. The petitioner surrendered, my lord, before, my lord, the police, my lord. And, my lord, he's 115 days now behind the bars, my lord. For our cases, my lord, this case of self-defense, my lord, there was some scuffle, my lord. And, my lord, we also suffered injuries, my lord, and all of them, my lord, the complainants, my lord, side, my lord, all of them have been charge sheet, my lord, but they are absconding.
Yes, the injured person implicated the petitioner also. He has the main blood.
That is on the basis of confessional statement, my lord, that I have purported confessional statement, my lord, that I have been named in the charge sheet.
No, is there no eyewitness to the occurrence?
Well, no one has, my lord, said, my lord, that I had, my lord. It's only the charges have been given on the basis of the confessional statement, my lord.
The injured person is the eyewitness that he has implicated the petitioner in the main blood.
And they're all abscond because this person's, my lord, the complainants and the entire family, they're absconding, my lord. They've been declared to be absconded in the charge sheet, lordship will see that page 87.
Who implicated?
The injured person with the eyewitness of the incident.
No, the injured person is expired.
No, another injured person or the other. Single person to injured.
These are from my side, our side. We also got injuries. Lordship will see, my lord, all of them are absconding, my lord. Page 80, my lord, that charge sheet, my lord, is at page in the other on the FIR which was filed by us, my lord. The charge sheet is, my lord, page 75. It starts, my lord. Lordship will see, my lord. Page 87. From the facts and circumstances revealed during the investigation, it appears that the accused persons have intentionally absconded since the date of the incident to avoid arrest. So the complainant side, all are absconding, my lord. Lordship will see page 87, second paragraph. During the course of investigation, it was learned from the statements of the complainant and injured victims and other witnesses the occurrence arose from a long-standing land dispute between the parties. It transpired that the complainant's mother, Maheza Khatun, had inherited and taken possession of a portion of land from her mother, and since the complainant's family has been peacefully living, possessing and cultivating the said land. Subsequently, the deceased Nur Alam allegedly forcefully occupied the disputed land and prevented the complainant's family from cultivating or carrying out any work thereon. It was further revealed that on 12/4/2026, during the daytime, the complainant's brother Nur Salam went to the disputed land to carry out cultivation work. At that time, accused Sofikul Islam, allegedly at the instigation of Zakir Hussain, along with Nur Alam is the deceased person, my lord, Akirul Islam, Afruza Khatun, and Zohurul Islam arrived at the place of occurrence being armed with iron rods, bamboo sticks, and dagger, and restrained him from working on the disputed land. During the altercation, accused Safikul Islam allegedly attacked Nur Islam with a dagger, aiming a blow at his head. To save himself, Nurul Islam raised his left hand, whereupon the dagger struck upon his left hand, causing a deep cut, injury, and fracture of the bone. Thereafter, the remaining accused persons also joined in the assault and voluntarily caused injuries to the other victims. During the hue and cry, the local people rushed to the place of occurrence, rescued the injured person from the clutches of the accused, and shifted him to the hospital for treatment.
Okay.
This is on the other side. And for I am concerned with the FIR, the charge sheet has been given, my lord, basically on the confessional statement that I had confessed, my lord, that I had hacked this person.
Okay, according to him, another injured person is there. Who is that person?
Page 26, my lord, is the charge sheet, my lord. In our case, my lord, against me, my lord. Page 26, my lord, shows that I had surrendered, my lord. The person connected with the death of the late Nur Islam Alam surrendered himself to the jurisdictional police station and was interrogated. After being arrested, he confessed in presence of neutral witnesses.
So, Doctor, one injured witness is there. His name is Zakir Hussain.
My lord.
And he has clearly implicated you.
Well, I am cooperating with the investigation. Well, our cases, this is a total case of self-defense, my lord. Because they are the person who attacked, my lord. Lordship will see in their charge sheet, my lord. All of them, my lord, have been, my lord. Zakir Hussain also is absconding, my lord. He has also been named as an accused in that first case, my lord.
No, that cannot be a ground to grant you bail.
No, my lord, my humble submission is that since I am cooperating, I have surrendered, my lord. I am cooperating with the investigation, my lord.
No,
It's my lord, the charge sheet has been submitted.
That is
120
also
days.
not the ground.
120, my lord, 115 days has gone, my lord.
Nature and gravity of the offense has also to be
That is
taken
true.
into
My lord.
account.
But lordship will see, my lord, that so far as, my lord, the charge sheet has been submitted. I am cooperating with the investigation, my lord. Others are all absconding, my lord. Even, of course, one of the accused in this case also is absconding, my lord, in one of my brother.
Not that you have been charged solely on the basis of the confession made by you. There is eyewitness to the.
Well, eyewitness statement, lordship will see, my lord. Here, in the charge sheet, the emphasis basically is, my lord, on the, if I can see from the charge sheet, basically from the, my lord, confessional statement, my lord. Page 26 onwards, my lord.
There is one eyewitness, and that eyewitness was implicated you. Anyway, we'll pass the order.
Because the eyewitness himself was a, my lord, accused person, my lord. He's absconding, my lord. That's what the police has recorded, my lord. Zakir Hussain, my lord. Lordship will see page 87. Zakir Hussain is absconding. So therefore, my lord, this was a case where, my lord, both of the part, my lord, this Zakir Hussain had, my lord, reasons to be, my lord, to say against me.
Okay, we'll pass the order. Yes, next item.
May I please, your lordship? Lordship, 482 application, my lord. The allegation is
can be seen, my lord, but it is not optical, my lord. Even, my lord, 182nd of the fifth is not there.
But my lord, this allegation is basically POCSO 8, my lord, where maximum punishment is 5 years, my lord. And as per order dated 1/4/2026, my lord, interim is there, and the petitioner have appeared the concerned IO, cooperated the investigation. In the meantime, charge sheet has been submitted, my lord, and the petitioner have received someone from the learned court below, my lord. And the next day is 25, my lord.
When you have been granted interim bail?
1/4/2026, my lord. My lord, I am ready to appear before the learned court below each and every date without fail, my lord. That earlier interim may be approved, my lord.
Yes, Mr. Sharma, he is already on interim bail.
Yes, my lord.
Remain, my lord, on interim. Let him remain on interim, my lord. In the meantime, my lord, statement of the, my lord, it is scanned for the updated. And my lord, amicus curiae also appointed. MS Brown, sir, probably, my lord, his name. That's it.
Amicus curiae is already appointed, my lord.
Yes.
And on that day, my lord, he was present, my lord. My lord, I am.
Is the amicus present?
Yes.
She inspected me immediately.
Okay, after some time, a letter.
Madam, what you want?
May please, Lordship. Lordship, up to date case diary was called for.
Here, city is not yet updated, madam. Here, one person the fire is not with site protection officer.
Matter relating to my lord child marriage.
When you have victim, my lord, admitted in a hospital, my lord, sold for a civil hospital, thereafter, the victim was minor.
So you were on interim bail.
Hello, petition number 3 is interim, my lord. Other is no interim.
And his statement is also not there.
No, you produce the updated case diary. When? Heard Mr. Hawk, learned counsel for the applicant. And Mr. Borthakur learned additional PP for the estate respondent. Mr. Borthakur submits that though he has received the case diary, the same has not yet been updated by the IU, and it prays for granting him some time to produce the updated case diary before this court. They are allowed. Till then, interim order dated 8/5/2026. Shall continue on
3rd September.
3rd of September.
Madam, 42.
42 mention করছি নাকি কল করা আছে
May I please, your lordship? Lordship, on last date. Pursuant to lordship order, we have appeared before the ISA. And then recorded.
Mr. Mahmoud Iwafa,
And what the information?
informant. Borthakur, CD received here.
Yes, received.
Okay. So he appeared before the IO
Yes.
and cooperating with the investigating agency.
Yes, statement recorded.
This petition is filed by 2 persons.
Yes, lordship.
Both were granted interim bail.
Both are interim bail after going to the city, lordship. They were just 1 year, 18 years, 6 months. That's
Any objection?
My submission is this. These two persons are from West Bengal. They came to district Kiran and did this them and went to a river for swimming. These 3 persons together went to the river, and after swimming with the 2 persons, these 2 prisoners came out. But the 3rd person was found missing.
then it was their duty at least to inform the guardian that that person is drowned or anything. But they did not inform the guardian of this boy about his missing. They remained silent, and thereafter, my lord, they filed this petition for anticipatory bail. Now, what you would say, the person who is dead, kindly see page 26. I don't know how the person before has come, page 26. He is standing in the river, he is standing. And there should be a followed, but he's just like a normal man. Of course, there are some indistinct injury marks, but 25 and 26 creates serious doubt. When a person is drowned, he will be lying on the ground, and after swelling, he will come out of the water. But here he is standing.
Lagoon. It's called
There was a serious doubt. And
When these photographs were taken,
Hello?
when these photographs were taken,
That information immediately after at the time of recovery. With the police
when the
report,
body was recovered,
Hello?
when the body was recovered,
After 4-5 days.
4-5 days.
And the police went there and in front of police, those pictures.
No, merely because the dead body was in standing position, it cannot be said that he was murdered.
But it is, my lord, very suspicious matter. How a person after drowning can remain standing, and these circumstances directly point out to them, because
No,
these
no,
three
no, no,
persons
no.
went to the river together to have a bath. The truth came out, it was whether if third person is missing or anything else, they should have informed.
So what is there in the case diary?
He was doing six bath, but one is missing and two boys were comes from the river, and they are in just the villagers. They will see that yes, three boys were there. Later on, the two boys will comes off and they have asked about third person, third boy. They fled away from the place. That's what they kind of the villagers. But later on, they have informed the mother side and even asked them whether he has come or not. But in the postmortem report, the remark is there, and diatom test was report was there. In that report, that was positive. That topic.
Drowning.
Only because of death of kitchen.
So postmortem report does not indicate any injury mark on the
Yes.
person of the deceased.
Got it.
Mr. Mahmood, where you have got the injury mark?
This is Lagoon. This is Lagoon Lordship. Lagoon. This was the Lagoon Lordship. He's a Brahmin guy.
But in the ligature mark not detected on neck, on section neck,
It is Lagoon Lordship. This is a photograph. Is shown is a Lagoon. This is called in English. Sector threat.
Okay.
It was a sector threat.
They will face the trial, or we are not discharging them. We will only make the interim order dated so and so absolute. They will face the trial.
Granting bail, interim bail, normally court doesn't go to the death of the case.
Yes. Heard Mr. Sharma, learned counsel for the petitioner, for the applicants. Mr. Goswami for the respondent, state respondent, additional PT. Mr. Mahmood for the informant. Apprehending arrest in connection with Sidley PS case number 11 of 2026 under section 103 within bracket 1, 3 within bracket 5, 6 within bracket 2 within bracket small a of the BNS 2023. This application under section 482 of the BNSS 2023 is prepared by two accused, namely Kushal Sharma and Madhav Paudel, for grant of the privilege of PRS bail. It is to be noted here that above noted case has been registered on the basis of one FIR lost by one. Where is the FIR?
FIR is on page 9, Lordship.
On the basis of one FIR lost by one city, Yamkar Ja.
Yeah.
No. Page number 9. On the basis of one FIR lost by Shyamsundar Jha on 7th of May 2026. The essence of allegation in the FIR dated 7th of May 2026 is that is the son of the informant, namely Yamkar Jha, was missing from the locality since morning of 4th May 2026. Upon inquiry, he came to know from 4-5 women working in Tamil factory in the village Nepal Paradet on 4th of May 2026. His son was seen in company of two persons, namely Kushal Sharma and Madhav Paudel, who came to the house of his uncle, Sri Kailaraj Upadhyay of Gorubhasa. And thereafter, two Adivasi persons informed that the said three persons were seen going towards Gauhati River in the evening on 4th May 2026. And they have and the villagers of Sampar River also seen the three persons taking bath in the river having fun. And suddenly the villagers saw two accused persons emerging from the river in wet undergarment. And when questioned by the villagers about the about their near naked state, then both of them ran away. And thereafter on 5/5/2026 at about 6:30 p.m., he received the information about the recovery of the dead body in Sampa River. And he suspects that the two persons, namely Kushal Sharma and Madhav Paudel, are involved in murdering his son. So Sharma Learned Counsel for the applicant submits that this court by order dated 8/6/2026 was placed to grant the privilege of interim peer's bail, and pursuant to the said order, the applicants have appeared before the IO, and their statements were also recorded, and they are cooperating with the investigating agency, and under such circumstances, Mr. Sharma has contended to make the interim order dated 8/6/2026 absolute in the same terms and condition. Per contra, Mr. Goswami, learned additional PP, has produced the case diary before this court, and on the basis of the same, he submits that the applicants have appeared before the IO and They have been extending cooperation with the investigating agency. And their statements are also recorded. What is the stage of investigation?
Is the investigation of every completed or something. Sir, has sent to the FSL report is still waiting.
The witnesses were examined.
It is for examining.
Mr. Sharma also submits that the IO has examined the witnesses and sent the viscera of the deceased person to the FSL, and the report is awaited. On the other hand, Mr. Mahmood, learned counsel for the informant, has opposed the petition. Referring to the page number 26, 27, and 28. Coupled with the fact that after the commission of the offense, the applicants were absconding, raise suspicion about the involvement with the offense of murder. And under such circumstances, he has opposed the petition. But having heard the submission of learned counsel for both the parties, this court has carefully gone to the petition and the documents placed on record, and also perused the case diary with the assistance of Mr. Usami, learned additional paper. It appears that by the order dated 8/6/2026, the applicants were granted the privilege of interim period bail, and pursuant to the said order, the applicants have appeared before the IO and their statements were recorded, and they are cooperating with the investigating agency. Further, from the case diary, it appears that the IO has achieved significant progress in the investigation of this case, and the case is pending for collection of the visceral report of the deceased. And in that view of the matter, custodial interrogation of the applicant seems to be not warranted here in this case, and accordingly, this application stands disposed of by making the interim order dated 8/6/2026 absolute in the same terms and conditions. CDB return.
Greatly obliged, sir.
43.
Last date plate.
FSL. FSL report was good.
Not received yet.
Then
You have been granted sufficient time to produce
Yes,
the FSL report.
yes, madam. Perhaps fourth time.
Heard Mr. Islam, learned counsel for the applicant. Mr. Goswami for the respondent. Mr. Goswami submits that FSL report has not yet been received. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that Mr. Goswami shall produce the case, the FSL report before this court on 27th August.
In the meantime, they may be protected millet because not there is a baby millet, male baby millet. Is it about 3 years millet? That baby is with the petition about 3 months. Grandmother millet.
Let the FSL report
And
come. Will
it is,
take.
today millet is a third date millet. Today is a third date millet.
Maybe on next date we will consider your pair.
That may be observed.
In the event of failing to produce the case diary on next date, interim period of petitioner applicant will be considered.
Short will be given millet. 27. 27.
44.
But in the morning, I made a mention, Milord, for adjournment, Milord, that Milord, Mr. N.Z. Datta will not argue the case. I made a mention in the morning, Milord. In fact, CD was called for, Milord.
You see, CD is pending before the court.
My lord.
So when CD is pending before the court, the IO cannot proceed with the investigation of the
Milord, another aspect for Milord, because your lordship has allowed one regular bail that is fixed on 19 Milord. So can it be along with that from out of the same FIR?
On 19th.
19th, my lord.
In that case also CD is called for.
Yes, my lord.
Okay. On the appeal
No, my lord,
made
that-
by
that is
Mr.
for
Ali,
motion.
learned counsel for the applicant. It is provided that recess lays the matter on 19th along with a
My lord,
BA number.
The number, it is filing number is there, number is yet to be done, my lord. Filing number 7276/2026. Because I made a mention yesterday, my lord, your lordship was pleased to allow the listing on 19th, my lord. The petition has been filed on 12th of August.
Along with application with filing number
7276, my lord.
7276 on
Public
19th.
2026.
Until then CD will retain.
My lord. I am highly obliged.
May I please, your lordship? Lordship may kindly peruse the last order. And thereafter, lordship may kindly come to page number 15, the FIR, lordship.
In this case,
This short sheet.
submitted on 30/7/2020.
Under section
Under section. In the search.
There are, lordship, three accused persons, lordship, and lordship, all the allegations basically goes against the accused number one. Who is the husband?
let the scan copy of the record come. Heard Mr. Ahmed, learned counsel for the applicant. And also heard Mr. Borthakur, learned additional PP. Mr. Borthakur apprised this court that after completion of investigation, the investigating officer has filed search sheet being search sheet number 257 of 2026. 38/7/2026. Accordingly, it is provided that recess shall call for the scanned copy of the record from the learned trial court, including the case diary, fixing the matter on
28 August
sorted.
2024 August.
Highly obliged.
And 29.
FIR at page number 8 show. FIR was lodged 20 May 2026, lordship. Now subsequent development is there, one child is already gave birth by the victim, lordship. And accused petitioner is her own brother-in-law, lordship. They are residing in a same house. At present, victim also residing at the house of the accused petitioner. Now, charge sheet has not been filed for us in this case, lordship, till now. Charge sheet file one, lordship. Okay.
It is a search sheeted case.
That's what it is. Or PCR was, the charge sheet has been filed, lordship. PCR received, lordship.
And charges have been on 35/26.
Charge sheet code and all, now.
Charge is not framed yet, lordship. Target was 31/8/26. It was considered as a charge.
Now for the lordship, look after the victim and child, lordship. Petitioner is required to bail, lordship. She is
Petitioner is
required to release on bail, lordship, because she is residing in his house with her sister. Victim is the own sister-in-law of the accused petitioner, lordship.
what is the age of the victim?
Victim 17 plus, lordship.
17. plus.
Appropriate age is not
defined till now, Lordship, whether above 18 years, this is
What is this? The case is pending?
international transfer. Next date is 31, last date is the gone, Lordship. 31/7/26.
Charge has not yet been framed.
Not framed.
Yes, so what is your submission? Yes. No, is it the ground for granting him bail? Instruction from client.
Yeah, sure.
Heard Mr. A.B.T. Hawk, learned counsel for the applicant. Mr. Kusami, learned additional PP for the state respondent. Then Mr. Your name, please? Learned. Your name? As Islam for the informant. For the informant. This application under section 483 of the DNSS 2023 is preferred by accused. Sirazul Haq, who has been languishing in jail in connection with Vipuria case number 75 of 2026 under section 64 of BNSS 2020, BNS 2023, dated section 6 of the POCSO Act. Is to be noted here that above noted case has been registered on the basis of one FIR lodged by one Reena Begum, within bracket actual name withheld, on 28/5/2026. The allegation against the present accused is that being the brother-in-law of the victim and taking the advantage of absence of the parents of the victim, he has committed sexual intercourse with her on multiple occasions, as a result of which the victim got pregnant and carrying pregnancy of 9 months. Learned counsel for the accused submits that the accused was arrested on 21/5/2026, and since then he has been languishing in jail. He also submits that in the meantime investigation of the case has been completed and charge sheet has been submitted against the accused, and that the accused will take care of the victim as he happens to be her brother-in-law, and that he will also face the trial, and therefore he is contented to allow the petition. Per contra, Mr. Goswami, learned additional PP, has opposed the petition on the ground that at the relevant point of time, the victim was 17 years old. And he committed the offense having administered wine to the victim. The learned counsel for the informant, however, submits that as per his instruction, the accused will take care of the victim. Having heard the submission of learned counsel for both the parties, this court has carefully gone through the petition and the documents placed on record, and also there is the statement of the victim girl recorded under section 183 BNSS 2023, and also the statement under section 180 of the BNSS 2023. And also the statement of the witnesses examined by the IO. And it appears that at the relevant point of time, the victim has not completed 18 years. She has been carrying pregnancy of 9 months. And in no uncertain term, she has implicated the accused with the offense alleged in the FIR. Having considered above, especially the statement of the victim girl recorded under section 183 of the BNSS 2023, this court is of the view that this is not a fit case where the privilege of bail can be granted to the accused, and accordingly the petition stands dismissed.
Please, Your Lord.
I'm for a respondent.
My lord, my respectful submission before this honorable court is that, my lord, as I have received summon, my lord, from the learned court below, so I am ready to appear before the learned court below each and every day, my lord, without fail, my lord. With any condition, my lord.
Are you amicus here?
Yes, Your Honor, the engaged counsel is making another copy, so the matter will be taken up after some time.
Why?
My lord, in earlier also same thing has happened, my lord.
Let the amicus come.
Items for admission, item 25.
May I please, Your Lordship? This criminal appeal has been filed, my lord, against judgment and order of conviction dated 8/6/2026, my lord, passed by Special Judge Pokso Dhukuri, my lord, against judgment against sentence of 10 years imprisonment, my lord, offense under section 4 of POCSO, my lord. And on the very day he has been taken into custody, my lord.
Heard, Mr. Your name, please?
Mr. A.K.
Learned counsel for the appellant. This appeal under section 415 within bracket 2 of the BNSS 2023 is directed against the judgment and order of conviction dated 8/6/2026 passed by the learned additional session judge cum special judge Pokso Dhuguri in special case number 326 of 2024. Notably, by the impugned judgment and order dated so, the learned additional session judge cum special judge Pokso Dhuguri has convicted the appellant herein in special case number 326 of 24 under section 366 IPC, read with section 4 of the POCSO Act, and sentence him to suffer rigorous imprisonment for 10 years with fine. Under section 4 of the POCSO Act, and also sentence him to suffer rigorous imprisonment for 1 year and fine of rupees 1,000 with a default stipulation under section 366 IPC. Peruse the memo of appeal and the grounds mentioned therein. And also peruse the impugned judgment and order dated so and so. Admit. Issue notice to the respondent returnable in 4 weeks. Step be taken by speed post and also by usual process. Within a period of 1 week from today upon respondent number 2. However, no formal notice is required to be issued since Mr. P. Sharma learned additional PP entered appearance for respondent number 1. It is However, extra requisite copy of the memo of appeal be furnished to Mr. Sharma during the course of the day. This is called for the record. Then list the matter after 4 weeks.
One IA is there, my lord, or suspension of the
Here
sentence.
notice will go.
For release on bail, my lord.
And you want to file objection? This one notice to the respondent number 2. Okay, here also that notification as per the POCSO case conviction. Notice to the respondent as per that notification. এটা আগৰটো লিখিব এইটো to the office of the PP. Here also to the office of the PP. Within a period of 1 week from today. List the matter after 4 weeks. In the meantime, Mr. Sharma learned additional PP may file his objection.
May please, Your Lordship. It was statutory appeal, my lord. I've been convicted for 3 years, my lord, for cheating and, my lord, using unfair means in an examination, my lord. Your Lordship. Already on bail, my lord.
Heard Mr. So learned counsel for the appellant. This appeal under section 415 within bracket 2 of the BNSS 2023. Reduce section 19 of the Assam Public Examination within bracket measures for prevention of unfair means in recruitment at 2024 is directed against the judgment and order dated 8/7/2026 passed by the learned session Judge Sriram in session case number 21 of 2025. Is to be noted here that by the impugned judgment and order dated so and so, the learned trial court has convicted the appellant under section 319 and 61 of the BNSS 2023 and section 10(1) of the Assam Public Examination measure for prevention of unfair means in recruitment act 2024 and sentence him to suffer SI for a period of 3 years and also to pay a fine of rupees 10,000 with a default stipulation and also sentence him to suffer simple imprisonment for 3 years and to pay a fine of rupees 10,000 with a default stipulation under section 61 of the BNS 2023 and also sentence him to suffer simple imprisonment for 3 years and to pay a fine of rupees 10,000 with a default stipulation under section 10 within bracket 1 of the Assam Public Examination measure for prevention of unfair means in recruitment act 2024. Peruse the memo of appeal on the grounds mentioned therein and also peruse the impugned judgment and order dated so and so. Admit issue notice to the respondents returnable in 4 weeks. Stake upon respondent number 2 be taken by speed post and also by usual process within a week from today. However, no formal notice is required to be issued to the respondent number one since Mr. Sharma entered appearance and received notice. However, extra requisite copy of the petition of the memo of appeal be furnished to him during the course of the day. This is a call for the record from the learned court below. Release the matter after for it. You are on bail?
Yes, my lord. Page 34, my lord.
এখানে লিখে লবা। Taking note of all the facts and circumstances, the sentence so imposed by the learned trial court by impugned judgment and order dated so and so is then suspended till disposal of the appeal and the applicant is allowed to remain on previous bail. I instance disposal.
I am deeply obliged, my lord.
27.
Appeal against acquittal, my lordship. It's a dismissed for default for non-prosecution, my lordship.
Appeal against acquittal.
Yes, my lord.
Heard Mr. Swinson, learned counsel for the appellant. This appeal under section 419 within bracket 4 of the BNS 2023 is directed against the order dated 10/6/2026. Passed by the learned additional chief judicial magistrate Kasar Silsor in NI case number 288 of 2023. Notably, by the impugned order dated so and so, the learned trial court has acquitted the appellant. No, acquitted the respondent of the offense punishable under section 138 of the NI Act. There is the memo of appeal under grounds mentioned therein, and also there is the impugned order dated 10/6/2026. Issue notice to the respondent returnable in 4 weeks. Admit. Step be taken by speed course and also by usual process within a week from today. Places shall call for the record from the learned court below. Stopped up 4 weeks. This I is for
It is my lordship, leave for appeal, my lord, leave for appeal, right? And it has been numbered already.
first you ought to have pressed this matter
Yes, my lordship.
for granting leave.
Yes, my lordship. That number, it has been already numbered, my lordship. Actually, leave for application should come first, my lordship. Leave to file.
Heard Mr. So learned counsel for the applicant. This application under section 419(4) of the Code of BNS 2023 is papered by the applicant seeking special leave to appeal against the order of acquittal dated 10/6/2026 passed by the learned additional chief judicial magistrate Kasar Silsor in NI case number 288 of 2023. Learned counsel for the applicant submits that the applicant has instituted one NI case, being NI case number 288 of 2023 before the court of learned additional chief judicial magistrate Kasar Silsor, but by the impugned order dated 10/6/2026. The learned trial court has acquitted the respondent hearing. The learned counsel for the applicant further submits that the applicant is willing to file an appeal before this court, challenging the order of acquittal dated 10/6/2026. And as such, a price for according leave of this court to prefer the appeal. Fair allowed. Having heard the submission of learned counsel for the applicant and also considering the facts and circumstances on the record and the grounds taken for preferring the appeal, this court is inclined to allow this application. The applicant is granted leave to prefer appeal against the impugned order of acquittal dated 10/6/2026. In terms of above, this IA stands disposal.
Highly obliged, my lord. But please, statutory appeal, lordship, against conviction under section 10 of POCSO Act, lordship. 7 years punishment for 10 and 5 years punishment for conviction under section 354 IPC by the additional session judge Moregaon.
Okay, admit is no notice to the respondent, returnable and forest. Is the be taken upon the respondent number 2 through the Office of the Public Prosecutor, Gauhati High Court. Recessal call for the record from the learned trial court. List the matter after 4 weeks. IA issue notice.
Notice.
With place of lordship, my senior is on Lex matter may be passed for
Who is your senior?
T. Deuri.
On the pair
Kindly
being
taken
made
up,
by Miss.
On next.
On the pair being made by Miss.
P. Kumar on behalf of T. Deuri.
P. Core Learned Counsel appearing on behalf of Mr. T. Deuri.
T. Deuri.
This matter stands adjourned for the day.
30.
This is an application of section 528 of BNSS, my lordship, for quashing the entire criminal proceeding FIR and charge sheet, my lordship.
Not received.
Kindly hear me for a few minutes. If your lordship feel it's a case for interim, your lordship may grant it. May I submit few facts, your lordship? For a few minutes, your lordship feel interim can be granted, your lordship will decide otherwise, my lordship. If I cannot make out a case for interim, your lordship.
No, without record, can we consider your petition? Let the record come.
My lordship.
Or Mr. R. Amin.
Lordship, next date is 28. So can I pray before a lordship any date before 25, 26, my lordship?
Learned counsel for the petitioner and also heard Mr. Portakur, learned additional PP for the state respondent. Mr. Portakur submits that TCR was called for by the order dated 27/7/2026. And in view of the office note dated 12/8/2026, the record has not yet been received. Accordingly, it is provided that recessal issue urgent reminder to the learned trial court for transmitting the record. List the matter on 25th.
Deeply obliged, my lordship.
Item for hearing under order 41, item 45.
Part असेल नाही.
May I please, your lordship?
you are for the defendant
Yes, Lordship.
and Mr. Hawk for plaintiff. There is concurrent finding of fact by both the court below.
That is was an exhibit 3. It was sent for FSL. And the FSL report of Gauhati was accepted, but that was in a default. With 3. That is the case. This
FSL report, this is of government FSL
is
report,
in favor
and that is private.
it's in favor of that. But the reason is that it's was sent and it put its signature. There was delay of 10 years. Last of the 10 years. The first also reflected is 3.
With the advance of age,
Yes.
the signature may be different.
Yes.
Two opinions.
After
Maybe. Which one is earlier?
The FSL.
Gauhati.
What
Guwahati
is
one is
earlier?
earlier, Lordship.
And
It
that
was
report,
contemporary.
negate his claim.
Negative.
Yes,
And the later one,
Agra.
Agra.
it is in my favor.
That was sent subsequently that is after 10 years.
10 years.
That reflect it's 25th. That is the reason that we
Which is the substantial question of law relating to that issue here?
5 year, Lordship.
Five?
5. Page number 3, 5 year. Lordship.
Whether the trial court and the appellate court has taken care of this section 73?
yes, that is accepted because the strike was going on in favor of me. And even other
No. Whether the trial court as well as appellate court has compared the signature,
yes,
compared
and by themselves.
73. Is there was there two agreements?
After 1 month,
So where is the dispute in the second agreement?
Second one. We have admitted the first one that we have executed. But so far as second one is concerned, Your Lordship, we have disputed so far as the signatures are concerned. Our specific allegation was that it was forged, Your Lordship, not our signatures. Your Lordship. So far as what is report is here, report is concerned, it is in their favor, Your Lordship, and
No,
the second-
the question is why for the second time the matter was referred to FSL?
it is by court itself, Your Lordship, when we raised. Because
Court
it is
itself.
not that we have sent, Your Lordship, we have placed before the court, Your Lordship, the court has sent.
No, whether the court, while sending the signature for the second time, form an opinion in respect of the first report?
No, Lordship, no.
No.
It is not there, Your Lordship. Only recorded, one recording is there, Your Lordship. As the defendant dispute the signatures in exhibit 3 to be their forged signatures, the exhibit 1 and 3 were first sent to FSL Kahilipara Gauhati for examining an opinion as to whether the signature of the defendant in both the documents, first Bainama and second Bainama, are in handwriting of the same person or not. The scientific assistant of FSL reported after examination of both the signatures, they are in the exhibit 3 that they are of the same person, but the defendants are not satisfied with the report of the FSL and they again prayed for sending their signature for examination by the All India Forgery Detection and Fingerprints Bureau, Agra. Accordingly, this court allowed their prayer.
So you have prayed for?
Yes, sir. We made a prayer, Your Lordship, that has
No.
been allowed.
while one of the report is available, one of the expert opinion is available before the learned trial court. Where is the question for sending it again to another FSL, another forensic science laboratory?
I understand Lordship, but
Hmm?
another aspect Lordship over a 16C.
No, in order to send the same, there must be one opinion that the first opinion of the expert cannot be accepted. And thereafter, trial court has discarded the report submitted by the second. Second.
Appellate court's finding were based on history. But it was discarded.
So how this finding is perverse then?
Yes, that is the question that how perverse.
That apart, your Lordship, so far as 16C is concerned, your Lordship, there is no specific abandonment with regard to their willingness and readiness, your Lordship. So far as substantive question number 1, your Lordship.
Where is the plaint?
Plain connector 1, your Lordship. Page number 6, your Lordship, onwards. That is after expiry of the 1 month, your Lordship. Of course, that's the stipulation that made in the first agreement, your Lordship. And it is only after when we received the summon from the court, they have came to know that the plaintiff have prepared the first bylaw. I'm not a bylaw.
But there is concurrent finding of fact there also. Unless you show any perversity from the record, this court cannot go into the evidence again. It is not permissible. Hmm? What is there with you
Lordship,
to show that the finding in respect of 16C by both the court below are perverse?
only thing is that Lordship, there is no specific abandonments. And so far as the notice, they are relying upon your Lordship, it was received after 1 year, your Lordship. And Lordship will find that page number 13, last para, your Lordship.
No. In paragraph number 3, page number 7, it is stated that
It is their contention, your
arranging
Lordship.
the remaining consideration within the stipulated period, the plaintiff verbally asks the defendant to execute the final registered deed. What more is required? What is the
If
evidence
it
of
is within a
the
month, your Lordship, they have verbally asked your Lordship, then after 1 year, they have sent the notice, your Lordship.
after?
1 year, your Lordship. That after 1 year
No,
or
maybe. Is it not within the period of limitation?
one month limited, Lordship, so far as first bynama is concerned, your Lordship, 1 month period was there. Within 1 month, they have to
No, maybe when the cause of action arises
Cause of action, your lordship, after the expired
within 3 years,
yes, within 3 years.
then
That is within the
the case is instituted within 1 year. 1 year. And according to you?
within 3 years, your lordship. Then 6.
Then
It should be under. Yes.
Mr. Hawk, in fact, there no issue was framed in respect of 16C by either of the court. There is no discussion also.
Specifically, it is talked about.
But 16C is the main issue in the suit for specific performance of the contract.
But discussion is there, but the specific, my lord, it would.
No, is there any discussion also on that issue? No, though no issue is framed, whether any discussion was where?
So far as suit is concerned, your lordship, there is no discussion, but appeal. In the trial court judgment, there is no discussion. Appeal, lordship.
Better let us fix another date. You come prepared. Whether there is any discussion in any of the decision by the trial court or by the appellate court. Heard Mr. Sodhuri, learned counsel for the appellant, Mr. Hawk for the respondent number 1 and 2. List the matter on Tuesday, September 2nd week. 10th of September as part of.
Lordship, sorry, lordship, on last occasion you could not make in time, your lordship. On last occasion, sorry for.
May I please, your lordship?
Timing 40.
Lordship, the indexed counsel is still lagging
Okay, then on some other date.
My lord, if possible, my lord, kindly come to page number 11, my lord, that is affair. Whether the allegation is very
But the
dangerous.
amicus appear, you are on interim bail. Is there any urgency?
No, my lord, actually 25, here is the next date, my lord.
When?
25, my lord. This 25.
You are on interim bail,
Yes, my lord.
then what will happen then? On account of heard Mr. A. Islam,
Yes, my lord.
learned counsel for the applicant, and Mr. B. Sharma, learned additional PQ for the state respondent. Mr. Your name?
On behalf of MK Brown.
Learned counsel appearing on behalf of learned amicus, Miss M.K. Brown. Learned M.K. Brown submits that Ms. Brown is on leg. And accordingly, this matter is then adjourned, listed on.
If the application is necessary, because one statement is not.
Updated case record. Rescission call for the updated case record. The updated record of the scan copy of the record from the learned trial court. List the matter on 28 August. Over.
My lord, if possible, my lord, 29.
Interim order passed earlier shall continue.
Saturday. Earlier, please.